Buenas and half a day. This public hearing is now called to order, and the time now is 9:01 a.m., Monday, June 30th, 2025. This hearing is conducted by myself, Senator Telo Taitague, Chairwoman on the Committee on Economic Investment, Military Buildup, Regional Relations, Technology, Regulatory Affairs, Justice, Election, and Retirement. To comply with the open government law, notices of this hearing was disseminated to all senators and media via email and published on KUAM Monday, June 23rd, 2025, and the second notice on Friday, June 27, 2025. The notice of this hearing was also available on the Guam Legislature's website and the Government of Guam public portal. I would like to recognize those who are here in person and those who are watching from home. Welcome to your Guam Legislature. I'd also like to recognize those who are here in person and my colleagues, actually the senators that are here in person. And joining me today is Senator Sean Gumatauta, always on time. Senator and Vice Speaker Tony Ada, Senator Chris Duenas, and Senator Joe San Augustine. Thank you, colleagues. And copies, by the way, of the legislation and documents received ahead of this hearing can be accessed through the Google Drive link, which was emailed to you in advance. For the listening public, you can find the legislation on the Guam Legislature's website at guamlegislature.gov. And if you need assistance, please feel free to call the legislature at 671-472-3465. Before I begin, I would like to set some rules of engagement during this public hearing. When you speak, please make sure you speak directly into the microphone. And for the record, please state your name, position, and who you represent. I ask that those who are testifying today stay seated for any questions my colleagues may have, and then you'll be excused. I respectfully ask that we conduct ourselves professionally and respect each other's opinion. Those who do not comply with these rules will be removed from the room and prohibited from further participation, and I do mean it. The following bill on the agenda is Bill 82-38 COR. This bill was introduced by Senator Will A. Parkinson, who just walked in. Perfect timing. Okay. It's an act to amend Chapter 10 of Division 1, Title 10, Guam Code Annotated, to add a new 42A101I20 to Chapter 42A of Division 3, Title 7, Guam Code Annotated, to amend 42A101J of Chapter 42A, Division 3, Title 7, Guam Code Annotated relative to medical malpractice in the territory of Guam, and to cite this act as the Do No Harm, the Anti-Medical Misconduct Act of 2025. Now, before I begin, I ask again for us to enter this hearing with a real commitment to listen with empathy and respect, and that we speak only what is true and genuine. No fabrications, no agenda, just honesty and integrity. This is about real people, real consequences, and our collective responsibility to pursue a system that protects both patients and providers through fair, timely, and transparent means. I also understand the urgent need to support and strengthen our healthcare workers and their staff, which is why I continue to explore legislation strategies, such as a measure inspired by Texas House Bill 2852 to bring in internationally trained physicians and expand access to the care of our island. And to clarify for the record, this bill, Bill 82, was referred to my Committee on Justice because it represents a significant shift in Guam's civil liability structure. It seeks to repeal the current mandatory arbitration process in medical malpractice cases and replace it with court-based screening and adjudication model. This legislation concerns access to justice, legal process, and the protection of the constitutional right, not the regulation of medicine. However, I have no issue if this bill was re-referred to the Committee on Health. But in the meantime, I will work closely with the Oversight Chair on Health, Senator Sabrina Salas-Mantanani, on the bill as it progresses. So thank you. And at this time, I'd like to recognize Senator Parkinson. You are now recognized on Bill 82-38. Thank you.
Thank you, Madam Chair. Good morning to the people of Guam, members of the committee. Thank you for convening on this important hearing. And I greatly appreciate the opportunity to present Bill number 82-38. I introduced this measure with a passionate commitment to the victims of medical negligence. The victims of medical negligence on Guam, their patients and families who have suffered harm and then found the doors of justice closed. My goal is to balance reform that protects patients without unfairly burdening the medical community. We do not seek to drive any doctors away or diminish healthcare in Guam. Instead, we seek to strengthen trust in our healthcare system by holding accountable those few who do cause harm, while upholding the good reputation of the many honorable physicians who do no harm. Bill 82-38 aims to repeal Guam's mandatory medical malpractice arbitration requirement and replace it with a new pre-screening and litigation process. In essence, it would allow malpractice claims to be heard in court after a fair preliminary review, rather than forcing every victim to pay for private arbitration before they can file a lawsuit. I chose to title it the Do No Harm Act because the status quo is harming patients and eroding public confidence. This reform is about restoring the promise that if you or your loved one are injured by medical negligence, you will have a fair chance to be heard and to seek justice, just as you would anywhere else in the United States of America. To understand the need for change, we must examine Guam's current medical malpractice process. Under Public Law 2143, our island enacted the Medical Malpractice Mandatory Arbitration Act in the 1990s as a response to rising insurance premiums. Today, Guam is virtually the only U.S. jurisdiction that requires every medical malpractice claim go through mandatory and very, very costly private arbitration before a lawsuit can be filed. This is a unique legal barrier, one not faced by patients in any state on the mainland. In most cases, a patient can take a doctor to court, sometimes after a simple screening panel or mediation, but no state absolutely forces binding arbitration on all claims as Guam does. In that, we are a country first. What has this meant in practice? For the average person on Guam, the mandatory arbitration law has effectively slammed the courthouse doors shut. Arbitration is so expensive, often requiring hiring 3 arbiters and expert witnesses up front. One analysis noted that just reaching the first step of arbitration can cost tens of thousands of dollars. In fact, it's been estimated that a family may need around $80,000 just to initiate a malpractice case under Guam's current law. Most working families and elders in our community simply cannot afford that. As a result, very few malpractice claims are ever brought forward, even when there is merit. The harsh reality is that if you are harmed by a medical mistake on Guam and you are not wealthy, you likely have no real recourse at all. Guam's mandatory arbitration law, while perhaps well-intentioned when passed decades ago, has become an unfair barrier that protects doctors as a class at the expense of patients' rights. It was supposed to prevent frivolous lawsuits and lower cost, but instead it has prevented all lawsuits, including valid ones, and lowered accountability. As one longtime advocate put it, Guam law has all but prevented negligent, injured, or killed patients from seeking justice like everywhere else in the country, especially economically disadvantaged patients. Bill 82-38 seeks to fix this broken system by implementing a more balanced, transparent, and affordable process for handling medical malpractice claims. And allow me to explain exactly what this bill does and does not do. First, the bill repeals the mandatory arbitration requirement in current law. No longer would every claim be forced into private arbitration. However, and this is very important, the bill does not prohibit arbitration or mediation voluntarily. So if this system is truly working, then the people should have a choice between them. If a patient and doctor prefer to arbitrate or settle out of court, they remain free to do so. And indeed, the court can pause proceedings for mediation or arbitration by agreement. What changes is that arbitration would no longer be a precondition to filing a lawsuit. We remove the paywall to the courthouse. We no longer gate justice behind money. The bill repeals the mandatory arbitration requirement in current law. No longer would every claim be forced into private arbitration. In place of the old system, Bill 82-38 establishes a pre-litigation screening process handled by our illustrious Guam Superior Court. Rather than a panel of private arbiters, a judge will conduct an early review of the evidence in each malpractice case. This is similar to how some U.S. states use medical review panels or tribunals, but we are tailoring it to Guam's needs. Under the bill, when a patient files a malpractice claim in court, it will first go to a special hearing before a judge, essentially an open, neutral evaluation of the claim's merits. Both sides, the patients and the doctors, can present records, affidavits, and expert opinions about what happened. Crucially, the judge can also call a neutral expert witness if needed to help evaluate the case. After reviewing the evidence, the judge makes a finding. Did the health provider deviate from the standard of care? Did the cause the patient's injury? If the judges find the claim is not supported by evidence, the case can be dismissed at its preliminary stage, which protects a provider from a baseless lawsuit. On the other hand, if the judge finds there is a reasonable case of malpractice, the judge will issue a written decision outlining the findings and even a recommended settlement value for the damages. This decision then becomes admissible evidence if the case goes to a full trial. At that point, either party, doctor or patient, who is unhappy with the pre-screening result has the right to demand a jury trial within 30 days. In a sense, it's like an expert-informed probable cause hearing for malpractice. It filters out meritless claims, and for strong claims, it provides an informed evaluation that can encourage settlement or guide the jury. Let me highlight how this new process benefits both patients and doctors. For patients, the important thing is the process is affordable and accessible. Instead of paying tens of thousands to arbiters up front, a patient pays a normal court filing fee and gets a judge to hear their case. If their case has merit, it won't be thrown out just because they couldn't pay arbitration fees. Justice will not be for sale. For the doctors, the process is fair and efficient. Frivolous or unfounded claims can be dismissed early by a judge, sparing doctors the cost and stress of a full trial on a baseless case. This actually strengthens the shield against frivolous lawsuits without denying worthy causes. And that is exactly what we want. Moreover, the pre-litigation hearing allows disputes to be resolved based on facts and expert input, potentially avoiding a protracted courtroom battle if the evidence is clear. If a case does not proceed, the doctor will at least understand the claim's basis from the judge's written findings and can plan their defense accordingly. For both sides, the process promises more transparency. Court proceedings, even pre-screenings, are a matter of record, unlike private arbitration, which happens behind closed doors. This means patterns of negligence can't be as easily hidden. Repeated malpractice by the same provider will come to light, enabling the licensing board and hospitals to take appropriate action to improve care. Conversely, if a doctor is unjustly accused, a court proceeding can clear their name publicly. Transparency is healthy for the entire system. In short, Bill 82-38 does not create a lawsuit free-for-all. It creates a structured, public, and fair pathway for legitimate claims, while still deferring frivolous cases. It prioritizes patient protection, yet remains balanced for all parties. This approach is in line with how many U.S. jurisdictions handle malpractice. For example, Alaska uses a court-appointed expert panel to review cases early. Hawaii requires a pre-filing inquiry before a conciliation panel, but not an expensive arbitration panel. Guam's reform will be similar in spirit, encouraging early evaluation and resolution, but without the punitive cost of our current system. We will finally be bringing Guam's malpractice into the mainstream of American justice, while still tailoring it to our island's needs. I have heard the doctors fear that this bill will do more harm than good. I would like to explain to the people of Guam that all 50 states allow malpractice suits in court. All 50 states. And yet doctors still practice medicine in those places, often in far greater number than Guam. I also want people to remember that currently, under this arbitration regime, Guam has struggled to recruit certain specialists, a point even some doctors have made, noting that the protective law enables some generalists to work outside their specialty, undercutting incentive for true specialists to come because they know no accountability will be held for them. What we all should fear is a system that silently permits a few negligent providers to keep harming patients because they are protected behind a protected class, above the law, above accountability. By removing this blanket protection for bad actors, we improve the overall standard of care, which in the long run attracts good medical professionals and bolsters patient confidence in our healthcare system. Bill 82-38 is designed to screen out frivolous cases before they ever get to a costly jury trial. Our goal is not more litigation, but more accountability. The cost of negligence is already being paid today, but it is paid by injured patients and their families in the forms of disability, lost income, additional care needs, and trauma. When the legitimate claim is prevented by arbitration from ever reaching a fair resolution, those costs don't vanish. They are simply shifted onto the victim or onto public assistance and the fellow taxpayers. We all want to prioritize solutions that lower cost, especially for healthcare. And I submit that reducing preventable medical errors through accountability is one such solution. Fewer errors ultimately mean fewer claims and lower overall costs to the system. And finally, I want to point out that the current arbitration law has not demonstrably lowered healthcare costs for patients. Guam's healthcare costs are high and rising for many, many other reasons. Bill 82-38 is not about encouraging frivolity. It's not about enabling bad actors to continue in the system. It's about enabling valid claims to be heard. In fact, the pre-screening judge system is a robust filter against frivolous lawsuits. If someone tries to bring a truly baseless claim, it will not survive the preliminary stage. A judge will review the facts, likely dismiss it, and even possibly require the claimant to pay the cost of the proceeding for wasting everyone's time. There is a strong disincentive for frivolous claims. On the flip side, cases that are well-founded will now have a legitimate path forward, which is ultimately a good thing. I know the medical community has felt excluded from this proposal and urges collaboration on a better solution. I am not here to dictate an answer but to find one. A legislative hearing is precisely the time to refine the proposal collectively. If our healthcare providers see specific provision in the bill that could be improved, I am open to amendments. I have always said that I believe bills that do not get challenged grow weak. So I welcome the medical community to challenge the bill, to make this bill as strong as possible, because when this bill passes, we will have a better system at the end. If additional safeguards can be added to prevent insurance shocks or to ensure the medical board is involved when malpractice is found, I am open to those ideas too. We have a legislative markup process for this very reason. I trust Chairperson Taitague and Vice Chair Terlahi will guide a thorough review of this bill in the committee markup, inviting further expert testimony and even holding additional public hearings after revisions if necessary. I am open to all of that. What I am not open to is no change. No change to the system that is failing our patients. My commitment to you is that we will get this right. We will not rush something that is half-baked, but we will also not indefinitely postpone justice for patients that have already waited for too long. The status quo is not a lasting solution. That much is clear. So let's collaborate in good faith to perfect this bill rather than using collaboration as an excuse to delay. Before moving on, let me say to all physicians listening, I value you. My wife, my child, and I trust our lives to you when we go to the clinic or hospital. Nothing in this bill changes the deep respect the community has for your service. We know you save lives every day, and this legislation is not an indictment of doctors as a whole. I believe that ultimately a system that openly addresses malpractice will strengthen public trust in healthcare to the benefit of ethical and competent medical professionals. I'm committed to a patient-centered approach that also takes into account the realities of our healthcare provider faces. And we will proceed carefully. I also remain open to complementary reform. My door is open to the medical community and association and any individual provider who has ideas on ensuring that good doctors are protected from undue hardship, even as we hold bad actors accountable. Accountability and protection are not mutually exclusive. We can have both. In closing, Madam Chair, Bill 82-38 is about restoring faith in our justice system, faith in our healthcare system. It says that on Guam, we will not put any profession above accountability, and we will not leave any patient behind who has been wronged. It affirms that compassion and justice go hand in hand, just as we have compassion for those who are injured. We are just making sure that they have ways to seek redress. The current mandatory arbitration law was enacted with good intentions to curb cost. It has proven to be too one-sided and painfully unfair to patients without the financial means to actually fight this properly. Being poor or working class should never be a barrier to justice. I look forward to further conversations on this bill, and thank you, Madam Chair, for the opportunity to hear it. Thank you.
You're welcome, Senator Parkinson. At this time, I'd like to also, for the record, state that on BBMR, we received their fiscal note on March 19th, 2025. According to the comments received on Bill 82-38 COR, the Unified Judiciary of Guam is currently reviewing the attached legislation and has indicated to the Bureau that absent further information on the operational demands this bill may impose, the judiciary cannot determine a fiscal impact at this time. We also sent this bill to our legal counsel, who has reviewed with no recommendations, changes, or amendments at this time. Invites were sent To the Honorable Robert J. Torres, Chief Justice of the Judiciary of Guam. Corey Uggan, MSW, Executive Director, NASW. Dr. Alexander Wheeler, Chief Executive Officer, GRMC. Dr. Edison Manaloto, Chief Medical Officer, GMRC. Dr. John Ray Taitano, President of the Guam Medical Society. Gregory Woodard, Chairperson, Guam Board of Nurse Examiners. Nathaniel Berg, Chairperson, Guam Board of Medical Examiners. Dr. Mamie Balahaja, Chairperson, Guam Board of Allied Health Examiners. The Guam Bar Association, Dr. Thomas Shea, President, Guam Medical Association. Dr. George Macaris, Dr. Gamili Batala, Attorney Robert Keogh, Troy Torres, Candid News, Calvo's Insurance, Takagi & Associates, Cassidy's Association Insurance, Guahan Insurance, David Limboski, Nicole Flores, Dr. Ron McNitch, Monica Flores, Maria Espinosa, Monica Devora, Ken Leon Guerrero, and Anilin Largamis. Okay, and at this time, I would like to we have people that are on Zoom right now, and they were here very early, so we're going to have them testify first. Dr. Batala, I hope I didn't, sorry if I mispronounced it, Batalla. Sir, you'll be recognized first. Then we will have David Limboski, Sybil Chrysostomo. Please come to the table if I called your name, if you're here to testify. Scott Dula Bohan. This was oral testimony. I'm going to spell the last name, Dulebohn. Okay, please come to the table. Leanne, no, it's Lena. And last name is Leiscaman. You have royal oral testimony. Please come forward. Shadiah Constantine. You have checked off for oral testimony. Jay Sylvester. Vanessa Miller. Dr. John Taitano. Alves, Joanne Alves. Okay. Isa Santos. Asa Santos. Okay. Sullivan. Parma. We have also Sue, last name Sue, S-U, okay. Matson Cadwell. Wow. Oh, Dr. Akamoto? Couldn't read your handwriting. Okay, you're just here. There's nothing, sorry. Dr. Hun? Okay, Ginger Hanny. There, okay. I'm trying to get as many people on here as possible. Ramona Domin, Mitch Thompson, and I believe we have one more seat available for Dr. Thorpe. Okay. Usually, we're going to try and keep this, be conscious. I don't like putting a timer on anybody's testimonies, but there is a lot of people here, and many of you have to leave right away to care for your patients and those who need to get back to their families as well. So please be conscious of your time. I do accept written testimony. If you're unable to finish within, a few minutes, then please feel free to submit your written testimony to my committee. I'm very happy to receive it. So at this time, I would like to turn it over to our Zoom to Dr. Batala.
Yes, thank you very much, Madam Chair, for inviting me to give a testimony on this hearing. I am Gamaliel Bataya.
Okay.
I am a board-certified physician in pain medicine by the American Board of Anesthesiology. I'm now a retired physician, but I have practiced in Guam briefly last year. I would like to comment on Bill 82-38, taking into consideration my experience in the island. Currently, we are all focused about arbitration, but I think one thing that is not being addressed is the current definition of standard of care. So I would like to focus on this matter. Standard of care is defined on this bill as follows: the prevailing standard of duty, practice, or care by a reasonable physician in the same field practicing medicine in the community at the time of the alleged negligence shall be shall be the standard applied in the pre-screening, arbitration, and trial. Guam is a small island, and not everything available in the mainland is available in Guam. In many instances, availability of specialists is limited. Following this definition, if you are the only physician in your field of practice in the community, then you are the standard of care. In my short stint in the island, I have noticed numerous deviations from the standard of care in the mainland that is occurring in the practice that I joined, which I refuse to be a part of because of patient safety, ethical concerns, though some of them are also outrightly illegal. I suggest revising the definition of standard of care, setting a minimum standard in which physicians are held accountable. For example, there should be no excuse for not doing things that are available in the mainland that is the standard of care in the mainland. Otherwise, physician or a small group of physicians in the island would be free to set whatever they want to be the standard of care. Offering something that is not medically necessary or something wherein the risks far outweighs the potential benefits, perhaps for the purpose of financial gain, should never be considered a standard of care. This ends my testimony, and I'll be happy to answer any questions that anyone has regarding this.
Thank you so much, and thank you for your, making it kind of short. We do have a lot of people here. Next, I would like to recognize David Limboski. Please state your name and your position and who you represent. Thank you, sir. I believe you're muted. David, you're muted.
How's that?
Oh, we can hear you now. Thank you. Please go ahead. Okay.
So sorry. All right. Thank you, Senators, for allowing me to give testimony in support of Bill 8238 and to advocate to improve health care on Guam through medical accountability. I arrived on Guam more than 50 years ago. I have worked at several social service agencies in the government of Guam. I am a proud University of Guam graduate. My work life includes working with the most disadvantaged individuals of all ages on Guam. This is what separates me from the others giving Bill 8238 testimony who want to keep the status quo Mandatory Medical Malpractice Act, or MAA, intact. I have no skin in the game, so to speak, outside of having a dead 5-year-old child that died from very documented wrongful death medical negligence, unlike those with pure financial loss concerns, apparently. The people I speak of and why I'm here and who I am here for today struggle just to get by on a daily basis with no recourse to resolve the medical negligence allegation claims. No avenue to become whole again. They do not have $80,000 or $100,000 in their pocket to file the case, which is the estimated cost, if not more, under the MMAA. I have learned that people are often too embarrassed to write testimony or even challenge doctors when a loved one is injured or dies from alleged medical negligence, not to mention sexual misconduct. This is a big part of the reason that it took 35 years to get this issue of the lack of medical accountability caused by the triple MMA to be brought to light. This is where we are today. When the triple MAA was first introduced, as Senator Parkinson alluded to, it was done because of financial concerns. Doctors were doing too much testing. They were doing many treatments. They didn't want to leave any stone unturned. They wanted to make sure that all their diagnosis was correct and they couldn't be sued. Interesting, there wasn't that many malpractice lawsuits, but the financial burden of doing all those testing led to the enactment of the triple MAA to save money. That was a full pendulum swing in the opposite direction to lessen concerns doctors have that they may be sued if a misdiagnosis, which then now leads to less diagnostic testing and exposing patients to medical misdiagnosis, lack of proper treatment, and sometimes medical apathy, which is probably why all the clinics are closed this morning to protest this. Bill 82 is not about malpractice. It is not about poor people who cannot afford arbitration. And for sure, it's not about my son, Asher. Asher's gone. There's been many, many since then, hundreds maybe. It is about having a fair, affordable system for all medical consumers on Guam to be able to have their claims heard and attempt to become whole again, to protect their rights, to improve medical care, and to protect the medical community against frivolous lawsuits. Guam has great doctors. I've had some of the best doctors in my life on Guam. But when great doctors protect doctors who have histories of negligence, that's where the problems start. Medical negligence is stated to be the third leading cause of death in the USA. Statistically, it is estimated that 10 people die per month on Guam due to medical negligence. It is also estimated that 1% of doctors commit 32% of medical malpractice nationally. This number is likely much higher on Guam with no current medical accountability or ability to identify these repeat medical negligent doctors or to provide mitigation to prevent such negligent reoccurrences due to the triple MAA. And this one is very affluent. Guam is the only place, as was mentioned, in the U.S. that affords this kind of cover-up or protection. The biggest myth that we're going to hear today, and we've heard, and by the way, for 5 years we've been discussing this, the biggest myth is that Guam will not be able to recruit or retain doctors if Bill 82 becomes law. This is absolutely not true. No one has shown statistics or recruiting issues that will back this up. I have been in meetings here at the legislature in the past when doctors were asked if they would leave if reforms were passed. Everyone said no. I have asked Guam doctors, many, the same question on my own. All said no. And I think if you ask those doctors sitting there right now, are you going to leave if this is passed? They will say no, because there is no place to go that they have less accountability. According to Dr. Shea, in one of his Guam posts, Guam does not need doctors. We need specialists. The triple MAA makes recruiting specialists very difficult, as doctors on Guam are protected to work so that they can work outside of their own specialties. So when a new specialist arrives on Guam, he and she, in fact, must try to set up a practice, not only with the small population on Guam, which makes it difficult, but making it even more difficult is that he or she must compete against other local doctors who are not specialists but have been practicing in the new doctor specialty area, making big bucks thanks to the triple MAAA. Attorney Keogh in the 112 hearings called this malpractice in and of itself, working across trained fields into other areas. And triple MAA works against bringing specialists to Guam. As some of you know, presently there are serious allegations by one Guam doctor against another Guam doctor of doing procedures that may not be necessary with questionably trained staff using lower thresholds for prescribing treatments. The accusing doctor was told not to worry about malpractice when he was reluctant to do such things, such illegal things. He was told that no one would testify against him. These accusations, by the way, are documented, and some of you folks know about these. And they give a good example why the triple MAA has lived its life and why it has failed, and how the people of Guam may have been misdiagnosed, injured, and overcharged, all because of the protection that the law that everyone's sitting, and most people sitting there worships. Doctors come to Guam now with histories of medical negligence or sexual misconduct, and easily get licensed by the Guam Board of Medical Examiners. As much as they want to disagree. I've listened to almost every single board meeting over the last 6 years. They know they can work here without malpractice concerns, and cannot work anywhere else in the country. They are not even required to have malpractice insurance. Some of these doctors, as we know, then come to Guam and injure a Guam patient. The past Assistant AG Rob Weinberg for the medical board stated that Guam is known as a place where washed-up doctors can find work. Let's thank that on the triple MAA, the protections. The only part of this bill that I would change is to not have the Guam Board of Medical Examiners involved. I know that's a big ask. They have a history in these 70 cases under Dr. Berg over the last 7 years of never, ever deciding a favor of a complaint against a doctor. 70 cases, none decided in a patient's favor. Statistically, nationally, impossible. Dr. Berg, the chair, has gone out of his way in meetings with senators and in the past to make sure that accountability doesn't come to fruition. Also, they have a history of not acting on impartial off-file investigation reports paid for by tax dollars that find fault with doctors. In summary, this is what I think, and my research shows. In summary, the Mandatory Medical Malpractice Arbitration Act makes it more difficult to recruit specialists to work on Guam. It prevents identifying repeat medical negligence offenders and providing mitigation before others are injured or killed. It allows, the MAA allows for fraudulent and unnecessary medical care by undertrained staff or doctors, knowing they will not be held accountable. It correlates, the MAA correlates with higher costs of medical care on Guam, with no control or monitoring of unnecessary procedures. It prevents adjudication and claims as allowed everywhere else in the country to make victims whole again or take care of long-term medical issues. It gives the financial responsibility to taxpayers and insurance companies through medical services required to pay for injured victims that need care when they cannot seek accountability for the injury from the medical field on Guam, raising costs for the rest of us on island. And it definitely correlates with the demise of medical care on Guam. I'll end by asking one question. Would you pass Bill 8238 if you knew it would save a child's life or several lives on Guam? This bill is about saving lives, not saving money for doctors. Not passing this bill means we have to continue to sacrifice our loved ones on Guam. And there are clear statistics that support this. I just want to say one last thing really quickly. We've been talking about this in 2019. It's been 5 years. There's been 2 other attempts, Bill 112, and there's one before that as well, to make changes in malpractice. Now you have a group of doctors running around closing their clinics saying, oh, we didn't know about this, we didn't know about this. They've known about it. We've been talking about it for 5 years. It's all over social media. No doctor made an attempt to try and make a change so that consumers and injured individuals are taken care of. And then they're surprised that this Bill 82 comes up. This is not the last attempt. If this bill fails under the next government, there's going to be another attempt. And I would suggest to you folks in the medical community, sit down with consumers, not just your own people, and come up with something that will benefit everyone before the legislature passes a bill that you're not going to like. And I hope 8238 is that bill. Thank you very much, Senators. I appreciate it. Have a nice day.
Thank you so much, and thank you for joining us. And at this time, Scott Dula-Bohan, is he here? Okay. Yeah. Okay, then hold on, Dr. Taitano. You are still behind Lena Lesgun. You're behind Shada, Constantine, Sylventer, and Miller. Do you guys all allow Dr. Taitano to go before you? Okay, they all agreed, Dr. Taitano, so I just don't want to step on anybody's toes here. Okay, so you may proceed, Dr. Taitano.
I appreciate it, Chairwoman. Thank you very much. And thank you for everyone for allowing me to go forward. I am John Ray Taitano, and I was born and raised in Guam. I've been practicing medicine in Guam for over 45 years. I've been president of the commission, Guam Commission of Licensure, which oversees all the medical boards, the allied health boards, the nursing boards. Also, president of the Guam Memorial Hospital medical staff, retired Army soldier with a tour in Vietnam as well as Iraq, and also past president of the Guam Medical Society. We urge you to defeat Bill 82-38. The Guam Medical Society is composed of local doctors dedicated to serving the people of Guam. I'm also the president and owner of the Doctors Clinic, which has been on Guam since 1985 and still continues to serve the people of Guam. We are here not to avoid accountability. In fact, we have always been willing and available to engage in honest dialogue about how we can improve healthcare access and address grievances with patients who suffer unfortunate outcomes. But this bill, though well-intentioned, represents a dangerous unraveling of the very foundation of Guam's healthcare system. Let's be clear, Bill 82-38 is not a pre-screening bill. It does not resemble the majority of medical review panels or arbitration systems used across the United States. Instead, it grants judicial authority to award damages without a jury, without medical peer review, and without caps, all under the guise of efficiency. This is not reform, this is exposure. No evidence, no safeguards, no support. Again, no evidence, no safeguards, no support. The bill's author provide no evidence that the current mandatory arbitration system is unreasonably burdensome, nor do they prove that this new proposal would reduce costs, delays, or improve justice. What it will do, however, is flood our courts with lawsuits, many of which may be driven more by contingency lawyers than legitimate malpractice. This bill allows a single judge with little or no medical training to serve as fact finder, gatekeeper, and even damage awarder without any requirement for medical expertise on the panel. That's a radical departure from arbitration systems in 27 other states, the District of Columbia, Guam, and Puerto Rico, which rely on medical professionals to guide decisions about clinical standards of care. Removing physicians from this process means that people judging us may not understand what standard of care truly looks like, especially in Guam, where we often practice with limited resources, workforce shortages, and higher patient acuity. Let me be blunt. If this bill passes, malpractice insurance premiums will spike as insurers price in uncontrollable risk and limitless damages. Frivolous lawsuits will rise as attorneys take advantage of a system with few safeguards. Guam will lose physicians. Many will leave, others will simply choose not to come. Why would a young doctor with their family come to a medically underserved territory where they can be hauled into court at any time with no medical review and potentially bankrupted? In the end, it is our patients who will suffer. They will wait longer for care, they will travel off-island more often, and they will face a healthcare system hollowed out by fear, liability, and burnout. A better path is possible. We are not asking to silence victims. We are asking for balance. We are open to modernizing the arbitration process to make it more transparent, affordable, and responsive. But this conversation must include all stakeholders, physicians, patients, legal experts, and court officials. Rushing this bill through without real dialogue is a disservice to everyone. We cannot legislate good intentions and ignore bad outcomes. In closing, I implore this body to listen not only to lobbyists and political advisors, but to the real voices of Guam's physicians, those of us in clinics, in the emergency room, in operating rooms, doing our best to hold together in a fragile healthcare system. Bill 82-38 will do harm. Let us not pretend it will do otherwise. Reject this bill and let us work together on real reform. Thank you. Any questions?
Thank you, Dr. Taitano. Dr. Taitano, do you have a copy of your written testimony? We want to keep it for the record.
Yes, it was provided to you, Madam Chairwoman, and I already gave it to the back as well. It's there.
Do we have a copy? Because I don't see it on my pile here.
Dr.
So we want to make sure we have it.
He sent it to you and you acknowledged it.
Okay, we just want to make sure we have it for the record and for my colleagues to also be able to review it.
Perfect.
I know you have to leave, Dr. Taitano. Does any of my colleagues have any questions for Dr. Taitano?
Thank you.
Okay, thank you, Dr. Taitano. And then we'll start back up, and thank you to those who are allowing him to go first. I know he has a busy schedule. So the next one will be, of course, Scott, D-U-L-E-B-H-O-N. I'm anxious to hear what it sounds like, your last name. Oh, you can turn on the microphone if you need some assistance. Yeah, okay. Please speak directly into the microphone, okay?
Yes.
As close as you can. Okay.
I'm Scott Dulapan. I'm a neurosurgeon here in Guam. I've been here since before Myanmar. Myanmar was one of the reasons why I chose to stay. It was because of how everyone in Guam treated each other as we recovered. That really was an impressive thing for me. I came from a tort reform state, Tennessee, and was willing to come here to Guam because malpractice was not unburdensome in terms of coming to work. I've been nearly 30 years in neurosurgery. I've been very lucky not to have ever had a successful suit. However, I had 2 suits that were passed on to me over time. They took years to resolve, and both were thrown out because they were frivolous. That was in Minnesota and again in Tennessee. A system such as they have in Indiana would really be quite preferable, where a medical review panel would approve any suits going forward. It's a 3-physician program. I really think that that would make more sense than an unlimited liability. However, we have physicians that are at GMH versus GRMC versus GRC versus the wonderful clinics we have in town. All of the private clinics will have unlimited liability, and the GMH people will not. And that's really going to change the reflection of patients and how they get taken care of and what gets taken care of. If we look at, for instance, the stroke program is really a wonderful program we have, at GRMC and serves the community well. That will have unlimited liability. Why wouldn't people go to a GMH? Well, because they don't have the program. And, you know, we've been chosen to get that. I really think that we need to figure out how to have a better overall system of care. Thank you.
You're very welcome. And next is Lena. Your last name, please, if you can state it for the record.
Buenas and half a day. Thank you to the chair and senators of the committee for opportunity to speak today. My name is Lena Leishman. I'm a nurse practitioner at GRMC. And I have been a resident and patient of Guam for the last 8 years here. I originally came to Guam short-term as a travel provider, but like many of us who fall in love with the island, the culture, and most importantly, the people and patients I see every day, I chose to stay in Guam and make it my home. I am deeply committed to this community and to helping strengthen healthcare for everyone in the island. I stand today in strong opposition to Bill 82, known as the Do No Harm Act. While I absolutely support the intention of improving accountability in healthcare, the proposed removal of medical arbitration will cause serious and lasting harm to our ability to provide care on island. Over the last several years, I've personally rotated through multiple specialty areas, including urology, pulmonology, general surgery, as well as urgent care, emergency medicine, and hospital care, really to fill the shortages that we already have. This has been necessary because of the very real gaps in access to primary and specialty care for our patients that has existed for several years. But we're making progress. We're finally starting to see improvements in the availability of inpatient and specialty services with a shared goal of allowing more patients to stay on island for care instead of traveling off island for essential services, which incurs enormous financial and time burdens to our patients and their families. Bill 82 puts that progress at risk. Removing arbitration will make it harder to recruit and retain our specialty and primary providers, especially in private sectors such as GRMC, where I work, and other primary care clinics throughout the island. Malpractice insurance is already difficult to obtain for those coming to Guam. This bill increases legal risks significantly, which may result in extremely high premiums. In some cases, some providers or clinics may even lose coverage entirely. And what's most concerning, just having a claim filed against a provider going straight to court, even without any finding of wrongdoing, would automatically be reported to a national database and follow that provider for the rest of their career. That level of exposure discourages providers from coming to Guam and drives current providers away. It will increase costs as we have to pay more to attract temporary staff. It will worsen turnover, and it will increase something that we all want to avoid, defensive medicine. Defensive medicine driven by fear of litigation results in unnecessary testing and procedures and interventions. It burdens our healthcare system and doesn't benefit our patients. In fact, studies have shown that defensive medicine costs the U.S. tens of billions of dollars each year and in many cases leads to patient harm through unnecessary treatments. One peer-reviewed study from the Journal of Healthcare Risk Management estimated defensive medicine accounts for up to 20% of total Medicare spending. This bill doesn't just affect physicians or doctors throughout the island. It impacts nurse practitioners like myself, registered nurses, physician assistants, certified nursing assistants, social workers, physical therapists, veterinarians, and many other working in private healthcare settings on island. These are people who have chosen to stay, to serve, and to make Guam better. Our medical community has already suggested several thoughtful amendments to the current arbitration process within previous Bill 112, aimed at improving fairness and transparency while still trying to protect access to care. We're not asking to avoid accountability. We're simply asking for due process involving key stakeholders and targeting areas of weakness at the root cause prior to patient harm from medical negligence. A balanced system that allows legitimate malpractice claims to be heard while protecting the integrity and sustainability of Guam's fragile healthcare system. We love our patients. We care deeply about their health, their safety, and their ability to access care here at home. We want justice to be available when malpractice occurs, but we also want to protect the ability to provide care in that first place. I respectfully urge you to oppose Bill 82 in its current form and to work with the healthcare community to find a solution that preserves both access to care and justice for all. Thank you for your time, your service, and your consideration.
Thank you so much. We do have a copy of your written testimony.
Not currently, but I can email it.
Can you please? Thank you so much. Okay. And next we have Shadia Constantine. Is it how you pronounce that right?
Shadia.
Shadia. Shadia.
Yes.
Okay. It's a pretty name. Okay, please go ahead.
Half a day, senators and Guam community that is turning into this hearing. Thank you very much for the opportunity to share my testimony. My name is Shadia Santos Constantine, and I am an internal medicine physician working at GRMC. Yes, I'm a Santos, but I am a Santos from the other side of the world. Had I known that the fate would bring me to Guam, I would have not changed my maiden name. I have been working at GRMC as a hospitalist since 2017. And I'm here to provide testimony on my role as Director of Medical Education for GRMC, maybe bringing a little bit of a perspective of a clinician educator here. As many as you know, there are ongoing efforts to create a pipeline to develop our own homegrown physicians and other healthcare providers in the island. We have made great strides in forming alliances with several universities in the mainland, and we are very excited to bring a first medical student coming in September to work here for 2 years, doing her third and fourth year. That's a first, and this is an island-wide effort. At GRMC, we are also in the process of trying to develop the possibly first ACGME accredited residency. And that will be an exciting and much needed development in our island healthcare system, one that could help address our long-standing physician shortage. While I defer to legal experts on the details of the bill, I would like to raise this potential concern from the perspective of medical education. National research has shown that although the decision for a resident to choose a program or stay depends on many, many factors, the local medical legal climate does influences when physicians choose to stay and practice, particularly in high-risk specialties such as surgery, emergency medicine, obstetrics, and others. There is some examples that I have read in the literature, like in the Pennsylvania liability crisis, where they did surveys of residents, and a large number, probably 1/3 of the final year residents plan to leave the state because of the Pennsylvania medical legal climate. And of course, other institutions or organizations like the AMA and others have stated that a more favorable liability environment tends to attract and retain more physicians, especially in rural and underserved areas. Of course, every community is different, and I understand that ensuring fair legal recourse is an important value. My hope is simply that any change to Guam's current system will be carefully balanced to preserve our ability to attract the next generation of physicians, particularly as we work to launch our first residency program. I respectfully ask you to consider potential unintended consequences of Bill 8238 on medical education and physician recruitment in Guam. Thank you very much for your service and your ongoing commitment to improving the health in our community. Sijus Masi.
Sijus Masi. Okay, next is Selventer, MD. Turn on your microphone. Yeah. There, just press the button there. Okay. There you go. Okay.
Hello. Good morning.
Before you get started, are you leaving those who are just testified? Okay. Can you just sit down 1 second before you get started? I'm sorry to interrupt. Do we have any questions for these individuals?
Actually, I do.
Okay, can you have a seat, please? We just have a couple questions before you leave, okay? Okay. Senator Parkinson, you're recognized.
Okay, I just got a quick question for some of you folks. You folks are from generally other jurisdictions before you came to Guam. Am I understanding that correctly? Okay, so if we were to reform medical arbitration in some way, what state would you recommend as a model to follow? Because you have worked in other states.
Indiana.
Dr. Akimoto, if you can, please sit down. We don't have anybody. Okay. Okay, you can go outside then and listen to the monitor outside if you'd like. Okay, thank you. You're welcome. Thank you.
So, you know.
Thank you.
So, no, I really appreciate your perspective because, you know, you, I assume, are all very good doctors, and I can tell by the way you speak and the way you present yourself, you're all very kind and compassionate. And so I would like to know what jurisdictions did have systems that worked for you? Because Guam is completely unique in their system. No other system in the entire country is like Guam. And so I don't like the idea that we're reinventing the wheel here. So I would like to get your outside perspective on what models out there are working and fair, because you're all relatively new to Guam, so I think you kind of have a unentrenched position. And so, you know, I'd really like to hear what you have to say about it.
Well, Indiana has a lovely system of review by physicians prior to going on. They seem to be able to do that at no cost to the patient, and I think would be a very reasonable way of going forward. And you know, if we were formed without limits, I would probably have to leave the island. There is no limit in the Reform Act in terms of medical malpractice, which really is a worrisome thing as a neurosurgeon, and trying to bring other neurosurgeons in, that's one of the first questions that's asked by them. Hey, what is malpractice like in Guam?
What was the limits on malpractice in your last jurisdiction?
$200,000.
$200,000. And was that limit something that prevented you from practicing medicine? Was it overly cumbersome system?
I was happy there with the limit. I thought that was a reasonable approach to the problem.
Okay, and if we were to adopt some amendment, potentially putting some reasonable limits on, and caps, would that be something that you would be willing to support?
If you had a medical review prior to it going to court. I think the fact that it goes to court and becomes an automatic thing on your national data bank is something that would be really onerous. And so you have to have a medical review prior to being able to go to court.
And what state did you say you worked at, sir?
Indiana.
And you say Indiana has an acceptable system.
Absolutely.
And they don't have compelled mandatory arbitration.
Correct. They have a compelled medical review committee review the case.
Okay, and what about you, ma'am? What was your previous district? And what system worked for you in the past?
So Guam is actually the first system that I've worked in my current position. Prior to this, I was a registered nurse. I've worked in several states, Virginia, California, Colorado, Arizona, and grew up in Minnesota. And so I don't know as much about the malpractice there since I worked in a different capacity.
But their system was not, what's the word, preventing doctors from signing up.
There's always going to be medical providers. I think the cost for them, though, is much higher in those states.
And what states' regulatory scheme do you think worked the best in your travels?
More from my research recently, I've reviewed Indiana the most,
okay.
And I feel very similarly.
What about you, Mrs. Santos? Oh, I apologize. She said Santos earlier. My apologies. Constantine. Maiden name.
It's Santos Constantine, that's okay. I like to call myself Santos now that I live in Guam. I only practice in Pennsylvania, and I am an internal medicine physician, which means, to be honest, we don't pay too much attention to liability, which is wrong. We should. But I don't think Pennsylvania is an ideal for what I have researched, a little research that I have done so far. Those states that have a cap, which I have seen between 250, 200, 250, some have $500,000. But in my opinion, what gives me pause about this bill is the lack of a physician reviewing the case and the definitions of standard of care. For a little background, I have studied evidence-based healthcare. I have a degree on it from the University of Oxford. And during my practice in the United States, what I have seen in the UK, my practice in Panama, I have come to realize that the practice of evidence-based medicine has a lot of nuance. Now that I work in Guam and that I work in Japan, which is a completely different place. So having somebody that will only follow evidence-based medicine, that is not a physician judging the practice of medicine, it's really scary to me. Personally, I feel that having a physician panel, a peer reviewing what has happened would be something that I would support.
So just to be clear, as physicians, you do not trust the judiciary to be the one to have oversight on this. You don't trust the courts.
I don't trust that the courts have the expertise and the knowledge to understand the nuances that go into the care of a patient and the decisions that are taken when you are providing treatment.
Could you please help me understand, me and the people of Guam, why is it judges can judge everything else, but for medical cases that they are suddenly unqualified? They judge everything from the highest to the smallest cases of the land, but for this particular case, for this particular class of people, they cannot be judged by the courts. Could you please explain to me how that works? Like, because I'm having trouble understanding that perspective, and so I'm trying to understand it.
I can say that even judging another colleague, even following a set of guidelines, which now have advanced a lot, I think it's difficult when you are not into the environment. I just from my personal experience working here, many times when we don't have the advice of the expertise, that would be ideal in the mainland. We have to read and practice and take decisions with the patients to the best of our abilities. And I feel that if somebody doesn't, if a court doesn't have the knowledge and medical background, I think there is more chances that these kind of lawsuits will pass along, will advance in a more easier way. So it's not, I think that the judge might defer, might decide that this has merit because they don't have.
You don't trust the expertise of the judge. You don't think they're qualified to judge your class of a profession.
They might defer on advancing.
All right.
So
thank you very much, ma'am. I really appreciate the input. Thank you so much for your answers.
Thank you. There are no other questions for you. You may go ahead and your excuse. Thank you. To fill up the other chairs, I think Dr. Nguyen, you were called earlier. If you'd like to take the seat, we have a seat open. We also would like to call Jeremy. For AMC, is Jeremy here? Not here? Okay. When Luhan, L-A-U, well, L-U-A-N? Of course, I can't read doctors' handwritings. Nobody can, but Melissa Welby, anything? Okay, none. Okay, we're going to continue on. Thank you so much for being patient. Okay, You are now recognized.
No problem. I guess my name is Dr. Jacqueline Sylvester. I'm an obstetrician gynecologist, so a very, very high-risk field. I practiced for 27 years, and I closed my practice in December 31st, 24, hoping to semi-retire. I had heard about a couple of places, Guam, and they recruited me here, so I'm representing myself, but I am a contractor for GMH as well as SDA Clinic. The reasons I came, and I told the nurses, and I've told everyone, was because I heard it's a great place, the people are wonderful, the patients are appreciative, and that the legal environment was supportive of us. Again, like I said, we're in a very high-risk field. What I have seen here, working in GMH, is that it is a very high-risk. We are not one and the same at the states where I practice. I've practiced in a couple of different states, and it's not one and the same. Like the first physician commented on the screen, we don't have all the specialists here, so I get consulted to see, oncology patients. That's not what I do, but I have talked to people in the states that are in this field, and like you said, you do the best that you can. Love the patients here. I think the facilities and the nurses and doctors do excellent work here for what we have. And even, just on a day-to-day basis, I don't have what I would have at home in the hospital. So it's not one and the same. So I just wanted to say that anything that is going to deter physicians from coming here I would not be in support of. And again, I don't have to be here. I love the patients. I've actually recently decided that I think I'm going to stay, but I don't have to be here, and I could go retire. But I'm here to help the people. I love public health. My father was a public health dentist, and I came because I wanted to help the people. Wonderful people on the island, so thank you.
You're very welcome, and thank you for staying too. I appreciate it. Next on the list, we have Vanessa Miller. You are now recognized.
Thank you, Senator. My name is Vanessa Miller. I am originally from the Bahamas. I have been practicing obstetrics and gynecology for the past 25 years. I took off the last 3 years to take care of my father, who just passed away in May. I came to Guam in 2014 and stayed through the end of 2015 and had some very interesting experiences which impacted my desire to return to Guam. One of the things that I continue to tell people about is just a simple incident. I was lost the first night that I got here. Had to go back to the airport, probably because I left a suitcase, I don't remember why. And I got all the way to the mall and realized, nah, I can't be this far. Where is the airport? And I asked a gentleman, can you tell me where the airport is? He didn't tell me where the airport was. He said, just follow me. He took me to the airport. My father came to visit a year later, and he was just walking down the beach on a Sunday, and somebody said to him, hey, would you like a drink? He said, no, I don't drink. Oh, can I give you a soda? No, I don't drink soda. Oh, we have some water. At least you must drink water. Okay, I'll take some water. And my dad told that story multiple times. It just is an indication of the type of people that are here on Guam. And that's the reason I am happy to return to Guam. At the end of January, I came back as an OBGYN at SDA Clinic. I worked as an OBGYN in several tort reform states. One is the state of Texas. And tort reform simply allowed people to have caps on how much they are able to claim in a lawsuit. Places like Florida had a fund that doctors could contribute to so that if there were neonatal injuries, they could be protected, and it reduced the amount of their malpractice. Here in Guam, at GMH, for instance, if we're taking care of a pregnant woman who has complications, and we don't know whether her fetal heart rate decelerations are caused by one thing or another, in the United States, we could use instruments that could tell us exactly how well the uterus is contracting, or exactly how well the fetal heart rate is doing. We don't have access to those. And so to be held to the same standard of care as someone in the United States with that technology is very unfair, and it makes doctors worry. It makes us worry to the extent that we might want to do a cesarean delivery for someone who somewhere else would not necessarily need that, putting patients at unnecessary risk. And so we prefer to worry about whether a patient is having a fever because they're infected or because they're just having inflammation. We prefer to worry about how the baby is doing. We don't want to worry about whether the patient is going to sue. And so we're going to order that MRI or that CAT scan that would be unnecessary and just increase the cost to the patient. And so I believe that if, as my colleagues have said, if we have physicians reviewing before patients bring any cases to litigation, that reduces the burden on the court system. It reduces the worry and fear of medical practitioners, and it leads for a more balanced situation for all around.
Thank you, Dr. Miller. Thank you so much. At this time, we have Joanne Alves. Is that correct? Okay. You are now recognized, ma'am.
Yes, good morning. Good morning, Senators. My name is Joanne Escalante Alves. I am with American Medical Center. Next month will be my 2-year anniversary of moving to Guam, but I am a daughter of Guam, born and raised. I'm an islander, graduated from JFK. I am a Triton. I graduated with my bachelor's at the University of Guam. I am approaching my 2 decades in the nursing career and the past 10 years as a nurse practitioner. I was very settled in California, but I had a calling to go back to Guam, not just to care for my family, but to serve the people of Guam. Despite the challenges I knew I was going to face being a provider on Guam, I was excited to bring my training, my experience, and my heart back to this island that cared for me. I was born at GMH. This is more than just a job. It's a commitment to my community, my heritage, and my home. I am here opposing Bill 8238 because in my first few weeks of practice at American Medical Center, I quickly came to understand a very hard truth, that practicing medicine on Guam or advanced nursing on Guam is not for the faint of heart. It is not for the weak. I say that because despite Guam being a U.S. territory in this modern 21st century, Guam faces many of the same challenges seen in rural America, often magnified by our geographic isolation. Practicing on Guam is rural medicine, rural nursing. We work with limited resources, scarce specialty services, and we serve a population with high rates of chronic diseases. These conditions just don't make patient care more complex. They also create what I consider a high-risk legal environment for all providers. In a place like Guam, where every provider truly counts, every provider counts here, arbitration is not just a policy option, it is a lifeline for us providers. It keeps clinics open, it helps to retain healthcare professionals, and it protects access to essential care for our people of Guam who already faces way too many barriers. Without arbitration, we risk losing the very clinics and providers that our community depends on. The result is fewer access points, longer wait times. We will overburden the already overburdened GMH-ER and the steady emergence of a healthcare desert right here in the island that we all care for. Arbitration allows us to focus on what we are trained to do, which is to provide quality patient care, not navigate the constant fear of litigation or financial instability. Arbitration offers an efficient and balanced mechanism, especially in critical areas like Guam, where the loss of even one provider can disrupt the care of thousands. If we are serious about health equity and continued healthcare access to our people, protecting a more transparent and reformed arbitration is protecting that access. Senators, without this, Guam not only risks losing the wonderful providers raised and trained in stateside, but we also run the risk of losing sons and daughters of Guam, born and raised on Guam, inspired on Guam to pursue medicine or pursue nursing, and want to return to Guam. But if they don't feel protected, we may lose them. Thank you so much for your time.
You're very welcome. At this time, the three that testified, if you need to leave, I'm going to ask first if my colleagues would like have any questions for you. Colleagues, any questions here? Any questions here? Okay, there are no questions, so you can leave if you'd like to. Okay. Or stay. Okay, the next one on the agenda is, okay, Santos. We have, is Isaiah? Okay. You are recognized, sir.
Thank you, Senator. My name is Isaiah Santos, and I'm a doctor of physical therapy at the Guam Seventh-day Adventist Clinic, where I have worked for the past 11 years, and I've worked for 23 years as a physical therapist. I joined the people of Guam and the providers, healthcare providers, and the healthcare community in opposing Bill 82. This bill not only affects physicians, but all healthcare providers, as I've mentioned, including physical therapists and the people of Guam. Stakeholders such as people of Guam, healthcare workers, policymakers, and others have the right and the responsibility to be involved in the crafting of our healthcare policies that directly affects us. Unfortunately, that does not seem to be the case with this current bill. Bill 82 has the potential to further fracture an already fragile healthcare system. Bill 82 is the wrong prescription for Guam. I urge policymakers, people of Guam, and our healthcare community to be united in voting down this bill. Thank you so much. That's all I have.
Thank you, Mr. Thank you, Dr. Santos. Appreciate it. Next, we have Sullivan. Ms. Sullivan, you're recognized. Please. Go ahead and move the mic further down if you can. That'll help you. Yeah, you can bend all the way down. There you go. Okay,
thank you.
You're recognized.
I'm Pramila Sullivan. I have been on Guam since 1988, and at present, I'm the executive director for the Guam Medical Association, and today I'm going to speak on that position. Okay. Guam Medical Association opposition to Bill 82-38. The people of Guam today are fortunate. The senators of 21st Guam legislature were able to look at the future needs of our island and put into place a law that helped develop and advances in medicine today for Guam. The mandatory arbitration law created the tools needed by private enterprises invested to make the type of financial and personal commitments that saw Guam's private healthcare system grow to the level of technical sophistication and range of skills that we serving the healthcare need of the people of Guam today. Reducing both the needs for the expense of many healthcare procedures that previously mandated off-island travel to remain on island, and it created thousands of jobs on island as well. The current arbitration law has dramatically improved access to the healthcare care technology for all Guam's people. Every year, Guam's private healthcare system gets stronger and more diverse as new clinics open, and existing clinics and new technology, new skill sets, and more staffing, because the tools created by the Mandatory Medical Malpractice Act has worked to screen out the frivolous claims and meritless claims. Remember, Guam used to have only 2 main clinics with 1 hospital and handful of healthcare providers prior to 1991. Since the arbitration law has passed, look at the growth, including the opening of the Guam Surgery Center, Guam Regional Medical City, American Medical Center, multiple dialysis centers, physical therapy centers, Pacific Cardiology Consultants, IHP Medical Clinic, Evergreen Medical Clinic, Guam Urology Center, Lombard's Health Eye Clinic, multiple dental clinics, and the latest is Future Smiles Orthodontic Clinics, half-a-day medical specialist, multiple pediatric clinics, Island Cancer Center for Radiation Oncology, Guam ENT Clinic, Island Specialist Institute, Pacific Eye Center, Island Surgery Center, Wound Care and Hyperbaric Therapy Center, Guam Radiology Consultants, SOAR Physical Therapy, NewGen Physical Therapy Center, Express Care, Central Medical Clinic, Pacific Medical Group, Shays Clinic and Associates, multiple retina specialists rotating through Guam, Famalao and Wellness Center, Pacific Surgical Art Health Services of the Pacific, Guam Dermatology Institute, Mariana's Flute Clinic and Chiropractic, several psychologic centers, and many more clinics not listed here. These are the results of the current arbitration law that have helped our island improve what it is today. The arbitration law has set up Guam's healthcare infrastructure, creating thousands of jobs, increasing our life-saving skills, workforce, and serving thousands of lives on Guam. This is a law you do not want to repeal. The law was well thought through by many of the pillars of your political party, and some of them are still alive today. They had this vision for Guam, and it's working. Because of the current Arbitration Act, more investment in healthcare has taken place in Guam, in the private sector than in the government sector. The private sector now has more people, more specialized skill sets, and more medical staffing supports, such as nurses, technicians, and other medical professionals than the government sector. You make a drastic change in the rules of healthcare litigation without a compensating support mechanism to provide investor, there will be corresponding drop in the private investment. Without private healthcare infrastructure invested, the quality of healthcare will slowly deteriorate as the government will not be able to replace without further gutting the government tax revenue stream. Without strong public-private healthcare system, even the military families will be negatively affected. Many healthcare providers on Guam also serve at U.S. Naval Hospital. Guam for many years, and we know that military works with private physicians and clinics outside the military facilities to help alleviate strains and because of the lack of specialists within the military healthcare system as well. At the end of the day, you will have to create a very set of conditions that will force the future medical students to make hard decisions about where to set up their beginning medical practices. And I can tell you that Guam will be at the bottom of the list when they compare the legal climates. Okay. I have helped many students in Guam get into medical schools, and already some of them have asked about this controversial bill. And the answer to them, if Bill 8230 becomes the law, do not come back to Guam. It is a very dangerous atmosphere to be practicing here, especially as a young provider right out of training. The physician, but more importantly, the patients of Guam and those yet to be born urge you to withdraw Bill 8238 and work with us to continue to improve the standards of healthcare in Guam for the next 25 years.
Thank you, Ms. Sullivan. Thank you. At this time, do we have any questions for Dr. Santos or Ms. Sullivan? Nothing? Nothing? Okay. You are excused, and if you can, go ahead and sit in the audience. If you're very welcome to stay, as well as Dr. Miller and those who testified. If you can, sit in the audience if you'd like to, so we can call more people up to testify. So I appreciate that. Thank you so much. Okay, the next one on the list is Dr. Su, right? Okay, you're recognized, sir.
Good morning, Senators. I'm Kenny Su. I'm a doctor, a pathologist, and the chief medical examiner of Guam. I oppose Bill 82-38. I appreciate Guam to let me work here. Guam people need more doctors, not pushing doctors away. Bill 82 hurts doctor-patient relationship, and that would push doctors and other medical professionals away. Not to mention that you need more doctors to review doctors. Yes, the arbitration requirement is not applied in other states. However, we also know that those states are not that worse as Guam in recruiting medical professionals. So I don't understand the logic to compare Guam to other states. There are so many things we don't have here. We don't even have a direct flight to the mainland, Senator. Medical students and graduates are listening to this hearing too. Would they consider to come here under the Bill 82? While we are crying for more medical professionals here, Bill 82 is the last thing we need to do now. Bill 82 only make the doctor-nurse shortage even worse here in Guam. So I opposed a Bill 82. Thank you, Senators.
Very welcome. Thank you, Dr. Su. Next on the agenda is Mason Cadwell. You're recognized, sir. Please state your name for the record and who you represent. Just press the button, though.
Okay, Hafide Suzuis Malasi for the opportunity to testify. My name is Mason Caldwell, and I'm a medical student at the University of Hawaii, originally from Barrigada. I speak on behalf of Chalan Amti, an organization of medical students, residents, and undergrads, all aspiring physicians and health professionals with backgrounds from Guam and Micronesia, with a unified mission of improving the medical workforce in our islands through early health education and career exposure in high school, mentorship and support for college and medical students, and clinical and policy research, aimed at improving healthcare outcomes and delivery within the islands. When we wrote our personal statements to get into medical school, it wasn't the unique protections from medical malpractice lawsuits that inspired us to become doctors. We just believed that our families and loved ones deserve the best healthcare possible. But medical training is long. 4 years of college, 4 years of medical school, up to 7 years of residency, and up to 5 years of fellowship, all while incurring hundreds of thousands of dollars of debt and working for less than minimum wage while training. This process can be grueling, but what motivates local students from Guam, like myself, to go through this lengthy process is hope that in the end, we will use our medical skills to serve the people of Guam, the community who raised us. The physicians practicing on Guam have overcome this difficult process, and although they could have relocated to serve any number of places with more resources, higher salaries, greater opportunities to advance their careers, they choose to come to Guam and continue to choose to stay, despite high-risk conditions, short-staffed work environments, and drastic lack of appropriate resources critical to patient care, and no safety nets available. Ultimately, they choose to stay out of respect, duty, and love for this community and its people. We love our island, its patients, and its doctors. However, we're incredibly cautious of Bill 82-38, as it proposes an overly simple solution to a complex problem without an included plan to address its shortcomings. We will outline why we believe that Bill 82-38 is anti-doctor without being pro-patient. Bill 82-38 replaces arbitration with a quote-unquote pre-screening process. Essentially, in cases where patients believe they may have experienced malpractice, their legal first-line course of action will be to sue their doctor. This leaves it to a judge to decide if evidence supports the conclusion that the doctor failed to comply with the appropriate standard of care, and that the conduct was a factor in causing damages to the patient. We agree that our healthcare system must improve to provide safe, quality patient care. There are patients that have been and will be harmed by the system and deserve justice, regardless of their socioeconomic standing or background. We believe that patients harmed by true medical malpractice deserve justice, and an accessible, timely, and straightforward process of legal action should be available to these patients. However, the proposed bill will simply replace arbitration process with a court trial. This will subject a patient's case to the time availability of Guam's court system, which already is short-staffed and has long case backlogs. Compared to arbitration, patients will likely experience a prolonged process to receive the recourse and financial compensation they may be justifiably entitled to. Bill 82-38 would also require patients to take on the financial costs of a court trial. Patients would have to drain themselves financially on legal fees for long, often drawn-out court proceedings. Removing arbitration appears to exchange the financial costs associated with arbitration for publicly exposing the licenses of doctors. This may be the goal for a patient who believes they have been so egregiously wrong, but is likely a minority of cases. For those who have no intention of settlement, arbitration can be a redundant extra cost. But not having it at all means that every dispute, including those that are frivolous and without merit, can contribute to a history of trials and settlements on a doctor's record that can unnecessarily result in license revocation in an underserved medical area that already has difficulty in recruiting and retaining physicians. Furthermore, Bill 82-38 will place increased financial and time burdens on doctors who are already overextended, work grueling hours, and making do with the very limited resources they have available to care for their patients. In the setting of increasing cancer incidents, high rates of diabetes and hypertension, and rising population from the military buildup, wait times can be expected to increase and/or care will be delivered suboptimally. Ultimately, the stresses of a culture of litigation, financial costs for medical malpractice insurance, and time spent away from doing the work that physicians actually sign up for, seeing and caring for patients, all perpetuate burnout, leading to physician relocation, early retirement, and potentially suicide. All of these issues will have negative effects on patient care. This is deeply troubling for many of us who want to come home and practice on Guam, because when we do come home, Anytime there's a lawsuit, we will be forced to cancel patient care time to participate in years-long court cases to defend our license, so that we continue to care for patients. Bill 82-38 will place increased burden on our already far outstretched physician workforce. For this reason, we strongly oppose Bill 82-38 as written. This dispute has brought to light a mutual concern for the improvement of healthcare delivery for our island. There are solutions to obtaining the intended effect of this bill, but it requires interdisciplinary collaboration in which proactive communication is essential. Bill 82-38 is not pro-patient and is anti-doctor. No one is happy with the current state of healthcare on Guam, not doctors, and most importantly, not patients. However, we cannot continue to approach the immense and complex issues within Guam healthcare with simple proposals that seek to divide members of our community with good intentions while failing to generate solutions, creating new problems without an included plan to address these consequences. Very respectfully, this proposed bill would benefit from focused discussions that include all stakeholders, current and future patients and doctors. We believe that we can find a solution that achieves the mutually intended outcome. We urge the Guam legislature to vote against Bill 82-38 as written and to create a more informed, detail-oriented, and comprehensive law that addresses both the incredibly valid physician and patient concerns cited in this hearing. We deeply appreciate your time and willingness to allow us to speak today. Thank you.
Thank you, Mr. Codwell, and good luck to you. I'm already calling you doctor. I hope you do come back to Guam after your studies. Okay, and I have Dr. Vincent Akimoto, who signed but didn't say whether he was going to testify. Is he out there? I know he was standing outside. Can you check, Deb, if Dr. Akimoto is still wanting to come in? Okay. That being said, we have Dr. Nguyen next on the list. So, Dr. Nguyen, you're recognized.
Thank you so much, Mr. Taitague. I just make it kind of simple and short, but my name is Huang Nguyen. I'm one of the principal owners of American Medical Center. We have about 40,000 patients in our practice, and probably the largest one. And I can confidently say that we have the most complicated patient of any clinic in Guam. It's a challenge to go to work every day without knowing what's coming through your front door and try to take care of patient. I just want to ask a simple question to all the senators, and including from the 35th until now. Is any senator in the last 3 or 4 legislature been in the healthcare sector as a physician, or nurse practitioner, health nurse, or anything healthcare related?
Dr. Nguyen, this is a time to testify. It's not. We're here to ask you questions, so you can put it in a format that
so
thank you.
The answer is no. So the question to everyone is, how do you introduce a bill to regulate the healthcare for the people of Guam without knowing the basic of healthcare? The basic. You know, I hear Senator Parkinson say it's from passion. I read a lot of Facebook or Instagram, and you cannot introduce a bill purely on Facebook or Instagram comment. It's nice to hear that you care, and I really appreciate that you care about the health care and the people of Guam. We do. We do appreciate that. But the healthcare community is telling you that it's detrimental to the healthcare system in Guam with this bill. That's why we oppose it. Kind of lets you know what's going on the daily practice in the primary care setting. I just give you some example, that way you kind of know what's going on. We are typically booked out 1 to 3 months ahead of time. 1 to 3 months. If you call my clinic now, you won't be seen to September and August or longer. With typical chronic illness like hypertension, diabetes, cholesterol, heart disease, and stroke, we book them all out. We follow our patient very close. In addition to our schedule, we triage 2 telephone calls from the patient to come in as a walk-in. Every day, someone going to get sick, and we have to see them. Now, you cannot shut the door on people that are currently sick at that day, and they want to come in to be seen. Walk-in can be simple, cough and cold, or it can be life or limb threatening. We don't know what comes in the front door every day. Now, despite triage on the phone by our team, that really we tell them, our patient, if you have chest pain or shortness of breath, go to the emergency room. Don't come to the clinic. We are not the emergency room, we're not the hospital. But they still showing up at the clinic and refuse to go to the ER. I'm telling you, every day we have that. So every day in our clinic, we're taking a huge risk. And we have no idea what the severity or condition of the patient who walk in the front door. Patients are smart. They're really smart. They know the system. They will tell the front desk on our telephone triage a simple symptom to get in. They do. I say, I just have a cough. But when you get into the clinic and you get into the exam room, they tell the provider a totally different story. And that's what we see every day. We have no idea. And we can't call the patient. It can be as severe as soon as you talk to the patient, you do the vital sign, you triage them, and you call the ambulance and transfer to the hospital for further evaluation and admission. That's what we do every day. Uncertainty in the clinic of who walk in the front door. The majority of our patients have chronic illness. Guam is one of the highest risks of them all. And everybody in the world have hypertension, diabetes, cholesterol. Everybody. I'm sure, including myself, everyone in this room, we have some chronic illness. We have to see our doctor, we have to take a medication. But good outcome for all this care is not just the competency of the physician. It requires the compliance of the patient, their lifestyle, their medication, their follow-up. And I can tell you, it's more than I can want to see. The compliance, the biggest issue of our patient. And that result in a lot of disease complications. They have a stroke, their kidney fail, they have a heart attack. And it's not because you don't have a competent physician. As physician and patient is 50-50. You got to make sure the patient follow. But I challenge you to see if we can find a compliance population. We are not. Our lifestyle on the island, we have party, we have everything on the island every day, every weekend, and patients just don't follow the thing. But they expect the physician and the medical community to be competent to keep them out of trouble. Now, I scold my patient every day. Every day that I come to work, and thank God the majority of my patients like that scolding because it's good for them. And I don't mind doing that because I think that's part of the trust that it gives in me in taking care of them. So I will continue to scold them, and they appreciate it. Come back every 3 months. And this is one example that compliance, and it's true thing. I won't mention the name, so that way, it's not a HIPAA regulation. But, in the past, we have a case of a child that showed up in our clinic, and the child was sick. We triage, stabilize the child. We call the ambulance, transport to the emergency room. The parents prefer to go by POV to the emergency room. They will go to the emergency room. So we discharge the patient, go to the emergency room. Unknown by us, the parent decide, the ER take too long. Let's go to another clinic. It takes about 2 hours or so in another clinic to be seen. And as soon as they lay an eye on that child, they call the emergency room, they call the ER and transfer immediately to emergency room. I think that case resulted in a claim. Now, who do you blame? Is the clinic that have some negligence, or you're going to claim, or the parents that doesn't follow the instruction? It's a gray line. You know, so it's very important when you make a decision on changing the bill that you have to know the healthcare system. You have to listen to people that work every day that have no idea what's going on. You go to a restaurant, a Chinese restaurant, you order Chinese food. You don't order Italian food and expect the Chinese restaurant to cook Italian food. You know, we have no idea. We are one part, and everyone in this room will have to try to handle those patients as best as they can. Bill 8238 will force the clinic and reduce their tolerance in providing care for the complicated patients who have multiple chronic illness and compliance to their treatment. Will reduce the urgent care and the walk-in due to high risk. You walk into my clinic and I take you straight to the ER, and that's a huge risk. I pray every minute that the ambulance will come on time, rather have to coach the patient in the clinic. That's every day. You know, the crash cart is there, it's ready. So, you know, from our standpoint, this is real fact. It's not a guess. We probably affect about 30% or more of our 40,000 patients. Where does patient go? What do you anticipate? Which clinic going to absorb this patient, that complicated patient? Not public health. This is a function. It's a responsibility of public health. Trust me, they will never be absorbed this type of severity, the number of patients that come their way. But it will happen. This is not against our oath that we take. It's a matter of the level of comfort to providing the care for our population. Accountability of negligent case, my goodness. Like I say, you have to understand when you talk about accountability. You talk about Guam healthcare system or the private healthcare system. It's two different levels. It's not the same. That's what we try to tell everybody for a long, long time. Personally, I don't see anyone from GMH here or public health. I don't see any. It really doesn't matter. There's two different systems. Everyone in here is the private sector. You see anyone from GMH? No, Dr. Kenny Su, he's a pathologist. He's not part of Guam employee. Guam healthcare system have their own government claim act. We set a cap of 300,000 or 500,000 to survive. They have a cap. Do we have a cap in the private? We don't have a cap in the private. Guam, you can sue them. Yes, they can settle with you, or you have to go through the arbitration still. You have to go through, and most of the time they will settle. But the biggest part that we in the private community are only concerned, you heard several physicians and providers in community, you know, for our name to be named in any type of claim, you know, is a name going to get reported to National Data Practitioner Bank? It's a really big hit. It's a big thing for us. We have to spend so much to defend that, even if frivolous, we still have to defend it. If it's against us, even if it's not our fault because they want to settle, our name is still on it. But for the government of Guam, it's the hospital. There's no name of physician. You want accountability? Work on that one first. Work on the Guam system and hold people accountable. On the private side, we do hold ourselves accountable, but we cannot help the Guam healthcare system. And that's what you have to understand is a two-level of healthcare. You change this law, this bill, won't affect GMH. The care will be the same. The lawsuit will be the same. The negligence will be the same. Because most of them is on that side of the house, not on the private side. But you will burden us with all the time and the cost in court. Retention, recruitment, physician. Now, I heard that earlier, Dr. Zabowski talked about retention and recruitment. I don't think he have any experience on recruiting retention physician. Most of the people in this room, GRMC, private clinic, I see a lot of them here, we know what retention, recruitment, physician is all about. My goodness, it's the most challenging task of any practice at recruiting and retention of this physician for Guam. This is the fact. It's not a thinking. Where does the patient make the comment, talk about it's easier to recruit retention? You know, Dr. Miller left already. She's an OB specialist. Everyone, the primary care physician in this room, we are so happy when there's a specialist on an island. It's not a competition. We will refer our patient to them. Why you hear about that they cannot survive because we want to keep our complicated patient? It's crazy. We are so happy. I just met her first time yesterday, Dr. Miller, and I said, thank you so much for coming back to Guam. You know, OB/GYN is so challenging for the women here in Guam. Why do you want to compete with our specialists? We are primary care. We want to refer them out to specialists. You find them, recruit them here, they have more work than they can ever have in Guam because we'd be glad to refer our patient to them. We want to keep them. We don't have a choice right now. So that statement that they're making there, they're not in the business of healthcare. They have absolutely no experience. That's just the line of thinking, and that's totally wrong. We want internists, we want specialists to be here. I kiss their feet for doing that because I don't want my provider to take that risk to take care of this patient when our counterpart in the state doesn't do that. Again, you know, improving healthcare system in Guam, just, you know, it's the emotion, the passion, and we have the same. We have the passion to care for our patient. I'm telling you, do we make mistakes? Of course we make mistakes sometimes. But is that intentionally? No. If you come in on the right leg complaint, I cut your left leg off, that's a totally different thing. That's gross malpractice. None of us, for dear life, the medical student, we spend so many years. That's what our commitment is for, guys. I mean, a sacrifice all our time away from our family, a lot of time away from our family, is to help the patient, never hurt the patient. We never do no harm to our patient. So the bill is really very detrimental. It's really create the negative thing and create much more division between the patient and the physician. You have your passion, but you gotta listen to us because we want to improve the healthcare system in Guam. We all want to do that. So, you know, this bill will affect everybody, the whole island, the rich, the middle class, the poor, everybody. And our commitment to care for the sick and to keep our island healthy, but we won't take unnecessary risks. We want to work with you to try to improve the healthcare system in Guam. So work with us. I tell you, we really need to sit down at a round table and talk about it and help you draft a bill. I think the bill like this in the public is really detrimental. It's not helping anyone. You know, so before that, please work on anything. We will work with you. But thank you so much for your time and your passion to care for our people in Guam.
Thank you, Dr. Nguyen. Also, Ginger Hanny? Okay, you're recognized.
Good morning, Senators. I am here today in opposition of Bill 82 because I care for the health of our patients. As has been mentioned many times before, we see very sick patients here on the island. There are many chronic diseases. There are many unrecognized chronic diseases in patients who don't go to the doctor often. I was just telling one of my colleagues the other day, whenever I have a new patient exam and the patient is over age 22 even, I automatically assume that they have several chronic diseases. They just haven't been recognized yet. And this is so often true. We get the walk-ins, like what was mentioned here. They come in for a simple cough, simple ear pain, and it turns into something very significant where they need to go to the hospital, or they have TB, or something very significant that needs to be managed and that we can't actually manage in the clinic. We do have a shortage of providers here in Guam. We have a shortage of specialists. It takes our patients months to get into specialties. I let the patients know this, and we do our best to manage them in the clinic when they really should be managed by specialists. But we're here to serve the people of Guam. We are here to increase their health, help them live the longest, healthiest, happiest life they can. I am very concerned about this bill because, as has been mentioned, this is one that provides significant financial detriment and difficulty for providers to continue providing care here on the island. Without protection or good protection, it will be very, very difficult to get people to come out to this island. We're a small island in the middle of the Pacific. In the mainland, many people don't know where Guam is. You say, oh, I'm from Guam. Where's Guam? So it's very difficult already to get people to come out here. It's medically underserved. It's rural. We don't have good resources already. And so passing this bill will make it very difficult to recruit. It would also make it very difficult to retain providers here. If there isn't protection, it's not sustainable. I have a colleague on the mainland who is practicing not here in Guam, but in a state there. And because of the malpractice and the litigation, ended up moving from a rural, underserved area where he was providing very needed services to another state in order to be sustainable. And this is a colleague who went into medicine because he wants to help people. He has a heart for people. He does humanitarian and mission work around the world on his own time, his own dollar. But he had to move in order to keep be sustainable. This is not about, protecting us as a class where everyone suffers. It's about coming to a good compromise where patients can have justice, because there are problems that occur that should be managed, and there should be retribution for that. But we need protection for the providers as well to allow us to continue the care for the people here on Guam that we love so much. Thank you so much.
Thank you very much. And we're going to go now on to Zoom. We have Dr. Mike Cruz, if he is available. Dr. Cruz, you are recognized if you're there. Okay, we just got a signal that he had to leave. Okay. Before I excuse you, I'd like to ask any of my colleagues if you have any questions. Okay, good. Senator Sabrina Salas-Metanani, I just wanted to recognize you as well. Welcome for being here, and also Senator Therese Terlahi. Senator Sabrina, you are recognized.
Thank you, Madam Chair. I just had one question, really, regarding this bill and whether you believe that it can be salvaged. I'm not sure what direction, what's going to happen with the bill going forward, but that was really my question on, do you think it can be salvaged if we included amendments or such as what was talked about earlier regarding the definition of standards of care, including a cap, including this medical review committee, this physicians panel, or do you think it really should be just scrapped and we start from scratch based on input from everyone involved?
No punch intention to Senator Parkinson. I can tell you from the majority of the healthcare community in Guam, the bill should totally scrap out and restart from square one. I think that, again, the fixing the arbitration require a lot of change on the Guam side of the house. So I think that we need to sit down at the round table along both the private and public and the senator and talk about how to come up with the bill that appropriately. So I would say that the bill needs to be take back and scrap out completely and restart it. Again, I cannot speak on the public side of the house, but on the private side of the house, we will sit down with every one of you, and we'll be glad to start square one and come up with something that is in the middle and not swing far to the left or to the right. Because, again, we have the same goal. The same goal is take care of our patient.
I would agree with this. I feel it is better to just scrap this one and rework from the ground up with input from all parties from square one. It gives a well-rounded view to the bill with important information that we might miss otherwise. We all want to take care of our patients, and we want it to be affordable as well. We know that Guam is expensive, and so I believe it is better to work it from the bottom up.
Thank you. Senator Metanani, you still have the floor.
I wanted to say thank you, Mason, for testifying. I've spoken with Kai Akamoto and other members of Chalan Amti. If this bill becomes law, is that pretty much the consensus that you future doctors, members of Chalan Amti, won't come to Guam or come back?
I think just in conversations, just as written, it doesn't present the best solution. I think whether or not everyone would decide to physically come back, if this was put into law, hasn't been fully discussed as of now. I think that would depend on how eager people are to come back, despite the working conditions, despite kind of the problems that can arise with this bill as now.
But for the most part, do you all agree that change is necessary, that we do need to change the current law?
Yes, absolutely.
Okay, thank you.
You're welcome, Senator. Senator Duenas, you're recognized.
Susmasi, Madam Chair. Dr. Wen, I want to make sure that we understand history once again, and I need to ask you this directly because I think we're painting with a broad brush, and I want to be clear that what your history and what your experience, and many of your experience has been with this. Have you made recommendations in the several iterations of this attempt and this bill in the past and have not seen recommendations taken or implemented in legislation via amendments in the past? Can you talk about your experience with regard to that?
I think on the 35th legislature, the discussion have come up with the same thing, with arbitration. And a group of us, including the provider from different clinics, from the hospital, the nursing staff involved, the dentists are involved, the physical therapists are involved, everybody involved, and met with the senator to suggest and recommend some amendment for the arbitration law. And it's a consensus of everyone, is to address everything that people worry about, address the cost of arbitration, assess the fund, assess the recommend on the judiciary part. Everything is on the amendment, but the amendment never hit the floor for discussion, never come together. So I don't know, we're not in politics. I don't know where it's going to hang up, but yes, the group of us have come up with amendment. I think at that time with, Senator Tina Munoz Barnes, and I'm very sure that we did make a huge, it took weeks and months to come up with this amendment, but it never hit the floor. And like I say, it's not us that hold back and then change for the healthcare system of Guam. It's in the politics somewhere. And this is where I'm pretty much 100% sure. I think it's on the 35th legislature.
Dr. Ho Wen, once again, didn't Dr. Jolene Uggan, along with others, prepare a approach to this which created a flow chart under which there would be a process in place, and also establish a fund to be able to assist with litigation going forward?
Yeah, again, Dr. Jolene Uggan, and I think Carla Haddock, Dr. Jonathan Thorpe, and several other physicians put a flow chart. It's pretty neat, and it's really pretty well thought of. And we just basically have a flow chart that will further divide to the explanation. Like I say, we really spend a lot of time, but again, we can only do so much. And when it hit the legislature had to somehow write the bill, introduce it, and talk about it. It never surfaced after so much time spending on trying to revise the amendment.
My final question, isn't it always been at the forefront that the medical community always knew that there was a disjointed situation, as you've mentioned? Because I think you cannot overstate this, that at GMH, there is not parity with regard to the private sector, and what you really do is you're kind of painted with the same brush, although you don't have the same protections, and that should have been one of the starting points going forward, and then build out from there in terms of a true system that can work for all.
I think everyone in this room is from private side of the house, and I can tell you 100%, none of them will disagree with what I say. That yes, there's one way to express our concern, the disparity within the private community healthcare provider and the Gulf Guam healthcare provider. We don't hold the same level of expectation. They really protect it very well for Gulf Guam, and that's the part where I say you cannot, because on the community, from the patient perspective, one physician in the Gulf Guam system make the mistake. For the community eye point of view, is we own the same. We own the same, and we are not the same. And I don't know if everyone in this community and the panel will understand that, but we are a totally different system. The public and the private, we are not the same. But in the eye of the community, we are the same.
Doctor, next to you, Dr. Wen, I'm sorry, can I get your name again?
Ginger Haney, I'm a PA.
Doc, I think the reason why my colleague is discussing the need to start from the beginning is, and this is why a lot of times amendments wouldn't pass or didn't get included, because what we then have is a charged political environment as opposed to trying to get to solutions. So my question to you is, in your effort and all the physicians who are saying start from scratch, is that designed because many senators who might try to put together and put forward the possibility of amendments and making this bill work could possibly get maligned for not being sincere about really fixing the system, but rather having a clash. Is that why you believe we should start from the beginning?
About having a clash?
No, about starting with a bill that basically takes into consideration, because I've made this suggestion before, and Dr. Wen knows this, is that what I really think we need, instead of this, we need a full-blown conference, you know, where we do this for so many other subjects. We need to set ourselves in a hotel room, maybe for a day or two, and sit down with all the stakeholders, patients, doctors, healthcare professionals, and the like, and really have, I know we're going to have a testimony from an attorney here soon, really have everybody in the room in order to be able to craft policy that's sensible for our community. And if we do that in that way, we avoid the back and forth on, you have an absolute system that's being proposed here, and then you're going to have a modification of that, and instead of really making that say that the product will be something that will serve all, it will be one against the other. You know, do you want the max? Do you want this process? Do you want a judge deciding? Or do you want a panel, you know, of physicians and a flow chart process that is best intended to get the outcome? I mean, that's why I'm asking you, is that your reasoning for saying, let's sit down and reason this out?
Yes, that is the reasoning. I believe all parties have very important input and important values that we need to bring to the table, and that we can find a very good compromise for all of them.
Thank you. That's all my questions.
Anyone else? Okay. Senator Parkinson, you're recognized.
Hi, I got a question for the young medical student. So among your talk with medical student peers, if this bill were to pass, is that their position that they would not be willing to serve on Guam?
And again, that was what I answered over here. We don't have I don't think a full consensus on whether or not we would come back. It would kind of depend on exactly how the bill would unfold, what we as a group kind of come to, and like what we see as the potential harms, how willing people are to come back and deal with the difficult conditions.
So let's take it away from a consensus. Let's take it to you. Would you not serve on your homeland of Guam if this bill were to pass?
I think at this point in time, I don't know enough about how medical malpractice actually works. I think at my current state of mind, after discussing with everybody, it would be a very difficult situation for me to come back to moving forward, especially depending on what type of specialty I go into, depending on what kind of procedures, what kind of capabilities I have.
In your research, what reforms would you be willing to accept on Guam?
I think the ones that have been kind of suggested so far, having all the stakeholders in patient care, medical providers.
That's a process question. I'm talking about specific policy changes. Would you be open into it to the courts, to a fully funded system? Like, what policy changes and flaws do you see in the system?
Mm-hmm. Well, I'm a medical student. I don't study public policy, so I don't know too much about that. I'm going to school to treat patients. I learn how to speak to patients, look at medical tests, medical symptoms, learn about the human body, and so that's kind of the extent of my knowledge on medicine.
All right, and Dr. Wynn, we've talked about, I've heard conversation about the community that this bill is come out of nowhere. But is it not true that this conversation has been happening for going on like 6 years now, that this is not a new bill? This is a bill that has been talked about for 3 years by various doctors. Is this not true?
You know, this bill come up as far as I remember, Senator Parkinson. The only thing that we as a community, including myself, I didn't know that there's a hearing today. Really, I didn't know. I heard this about a week ago as I traveled with my family in Vietnam, and I tried to organize and talk back to the medical community, but I didn't know it's on the date for the hearing today. You know, we tried to contact Senator Taitague to see, can we move this thing? Because Monday is the worst day of them all. You know, this is the busiest day of the week for us. But she says she cannot move because there's some whatever the 5 days grace period we had to announce. So we had to scramble to put all this physician and provider, everyone together for this. We didn't know it's today's a hearing. We didn't know like a week ago.
Yeah. Well, this bill was introduced in March, so there was plenty of time, and this has been a question that was asked during the election. This was after the election. This was introduced in March. We've had public notices, so this has not been snuck up on anybody for anyone confused about some of the rhetoric around. But my other question, Dr. Nguyen, is do bad doctors exist on Guam? Are there bad doctors on Guam?
The term of bad doctor is not the right term. I think that every physician at certain capacity will make a judgment error in what they treat the patient, but I don't think any physician is a bad doctor. We are physician, we are patient, we are family member.
How do you know there's no bad doctors?
When in the community on the private side, I can tell you on the private side only and not on the public side, okay, Guam side.
So, just to be clear, it's your position that there's no bad doctors on the private side and all the bad doctors are on the public side?
I think, again, the bad doctor is a bad term. Is that your testimony, sir? I think the physician that don't make the best choice of the patient. On the private side, if I need to refer my patient to some specialist, I don't feel like that specialist is the best, make the best judgment. On our practice, we don't refer to that specialist. It's not because they're bad. It's just that we don't feel like they make the best decision for our patient.
Is the private medical arbitration system we have now perfect? Is it working completely as intended?
No. That's why in the past.
So my question is, what changes would you be publicly willing to say you would accept to the medical arbitration system? What changes do you think you could accept?
There's a lot of change, Senator Parkinson. Could
you name one?
The funding source for the people that don't have the fund to go to the arbitration.
How would you change it?
That's one of the things that we discussed in the past. That's one of the point. It's not the only point, but that's one of the minor point that we do. Again, the funding source is not a major point. I'm telling you, it's not a major point. The major point
is there any version of this bill that you would be willing to accept with amendments?
I think this bill needs to be repealed completely.
So there's no version of this bill you would accept as it is?
Absolutely not. No.
Okay. Thank you for that honest position, sir. I'm looking forward to having this conversation on the floor.
We are too. Thank you so much, Senator Parkinson.
Senator Chalahi, you have any questions? Yeah.
Thank you. I'd like to hear the rest of the testimony. Thank you.
That being said, Dr. Nguyen, you're excused as well as Dr. Handy and Mr. Cadwell, right? You are also excused. At this time, we will now have Jeremy. And just before I move forward, I'm going to go ahead and ask other people to come to the table. I believe I called Jeremy, Ninjin, Melissa. Are they here? Okay, there you are. Okay. Also, Dr. Joel Joseph is here. Francis Santos. Alexander Willard. Okay. Dr. Loom. Okay. Robert Celestial. Can you double check with him? And I saw him walking out. And Ms. Espinosa, but you can stay seated until it's time to come up. I'll call you, okay. So we'll continue to move on. The next one on the agenda is Ramona. Sorry, these handwritings you physicians have is so difficult. Okay, you're recognized, ma'am, please.
Thank you, Senators.
Let's try and see if they'll adjust. Check your microphone, please.
Can you hear me?
Yeah, it's not on yet. He'll help you. He'll assist you. Okay, there you go.
My name is Ramona Doman. I'm a nurse anesthetist, independent practitioner. Been a nurse anesthetist for 24 years, in the Navy for 24 years, retired captain. So I am here to say that working on Guam for the past 12 years, I've worked in every OR except GRMC, practicing on the most sophisticated, sick patients I have ever met in my entire career. So I'm not sure what the physician was saying about recruitment on Guam. I've met 2 nurse anesthetists. They have come and left because one said your patients are too sick, and the other one said not all clinics have malpractice insurance for nurse anesthetists. So she left too. So recruitment, I believe this bill is going to affect recruitment. And my only second point is to say, not having the stakeholders at the table before the bill was drafted, number one. And 2, not taking into consideration all the work that these folks have done before me 3 years ago was another mistake, I believe, in drafting a bill. So scrap the bill, oppose this bill, get stakeholders at the table, all stakeholders, public and private, and like you said, Senator Duenas, perhaps we need to get in a room, all stakeholders, and draft a bill that can work to protect providers and also to protect our patients. There are some, quote, bad doctors. Nobody shows up to work wanting to harm a patient, but things happen with the complexity of the patient and the complexity of a medical system that's broken. And finally, I will say, Senator Parkinson, you asked why a judge cannot make a decision on medical care, but they can make a decision on everything else. It's because the human body reacts in different ways under different circumstances with different medications, and that's probably why medicine is so complicated that you would need physicians or nurse practitioners to help make decisions for arbitration going forward. Thank you.
Thank you so much. Attorney Thompson, you're recognized.
Okay.
Yeah, you're good.
All right. Madam Chair, committee members, my name is Mitch Thompson. I've been an attorney in private practice for over 38 years here on Guam. My testimony today is based on my experience while practicing here, and my opinions that I'm stating here today are my own. I oppose Bill 82 for several reasons. The first is that the bill as currently drafted is inconsistent and frankly unworkable. Under Section 10107 of the proposed bill, a judge is to hold a pre-screening hearing in camera promptly. What does that mean? Well, I think that's where we start finding some of the problems. First, what does promptly mean? Does that mean that the judge is to set the hearing within 10 days, 30 days, 90 days? We don't know. The hearing is to be held in camera. What does in camera mean? Well, that means it's not open to the public. It's not open to the public. That's what the phrase in camera means. So my question is, well, where is the hearing going to be held? If it's held in the courtroom, I guess it's going to be, the doors will be locked so no one can see it. Will it be held in the judge's chambers? We don't know. The bill doesn't say. Now, there was some discussion about, well, are judges unqualified to make this determination? Well, I don't think anyone is saying that judges are unqualified to make the decision. The question is, who is better qualified to make that decision? A panel of physicians or a judge? Judges go to law school. They don't go to medical school. Now, that doesn't say that a judge with sufficient experience and training might not be comfortable making decisions based on whether or not a physician's conduct met the standard of care. But who's better qualified to make that decision? For example, if I get sick, I go see a doctor. I don't go see a judge. Why would I go see a judge? Because the doctor is better positioned to help me with my problem. Now, there's some other problems with Bill 82. I think it's unfair to dump this decision-making process onto our hardworking, overworked judges. I think if you ask the judiciary, they would say, listen, wait a minute, you are putting this mandate on us, and we're not really ready to take it on. It's my understanding the Chief Justice has submitted a letter along those lines. And I think as one of the stakeholders that should be invited to the roundtable meeting would be representatives from the judiciary, because my sense is that if this bill were to pass, the judges are going to have to undergo specialized training. It's going to cost more money. But again, the judiciary is better able to give us their position on that, and they should have been invited, in my opinion, they should have been invited before the bill was drafted rather than after. Now, there's another big problem with the bill in that Section 10107 sets out the process for the pre-screening hearing. And it says that the judge is to make a determination whether or not the standard of care was met, whether or not any failure to meet the standard of care caused the harm, and then the judge also has to make a settlement value. Well, how is the judge supposed to do that? I mean, that is another specialized area that, again, I'm not saying judges are unqualified to make that determination, but who is better situated to make that determination. Another problem is that the bill is inconsistent because Section 10107 sets out the process through the pre-screening hearing. But then there's a whole set of other provisions that are inconsistent with that process. And I think it's important to note that all the judge determines under this bill, under Section 10107, is whether or not the standard of care was met, did a violation cause harm, and third, settlement value of the claim. But even if the claim is completely frivolous, under this pre-screening bill, as written, it doesn't mean the claim is dismissed. All it means is that if the plaintiff still wants to go forward, the determination by the pre-screening judge is admissible in evidence. It doesn't stop them from going forward. It doesn't mean that their claim, even if found to be frivolous, is dismissed. It just means that, oh, if we go to trial, one piece of evidence will come in, will be the judge's determination it was frivolous. It doesn't mean the claim is dismissed. Why is this a problem? Because as some of the physicians have alluded to, even if a claim is meritless, often because of the cost involved in defending it, and this is at trial, this is in court, oftentimes defendants decide it's cheaper to just settle and pay a claim, even if it's meritless, because going to court costs a lot of money. Lawyers have to get paid. Experts have to be hired. And so the notion that, oh, if we go to court, then it's not going to be expensive, it is going to be expensive. But why do parties settle claims even if they're meritless? It's because they don't want to have to keep paying their lawyers. They don't want to have to pay for expert witnesses. They don't want to rely on the whims of a jury. I mean, I like to think that juries make good decisions, but do they sometimes go astray? Yes, they do. So, what is the problem with settling a claim? Because any settlement has to be reported to the National Data Bank, even if the claim is meritless. That's not the issue. If the physician settles a claim, even let's say the screening judge found that it was frivolous, but because the physician doesn't want to have to keep paying the lawyer to defend the claim, if the claim will go away for $5,000 or $10,000, dollars and cents wise, it makes no sense to keep fighting it. I tell my clients that all the time. Listen, why spend $100,000 if you can make this claim go away for $10,000? But the problem for the physician or the provider is that that settlement has to be reported to the National Data Bank, and it's a black mark against that provider. Even if the claim was completely frivolous, they've got to report it. That's a problem. It's not fair, but that's the way that the current system is. So I want to talk about some other problems with Bill 82. And this is kind of I was complaining about some of the procedural issues with it, but I think maybe more importantly, there's a substantive problem here in that the Bill 82 states in the introduction that the cost of pursuing med-mal claims is prohibitive. Prohibitive. Well, I'll tell you right now, it's not. It's not that different from going to court. I'm defending 4 cases right now alleging professional malpractice in all of them. With the plaintiff's counsel, we've reached agreements on how to proceed under arbitration. Pursuing claims, whether in arbitration or in court, is expensive. But the notion that there's some huge number of unserved claims out there, I think, is based on unverified comments on the internet. This reminds me of a commercial that was out there some time ago where somebody said, well, I saw it on the internet, it must be true. No. And again, I'm telling you from my own personal experience. I am right now defending 4 claims brought in arbitration. The system is working. Now, the big winners of this bill, are the lawyers. They're the ones that are going to come out ahead. Now, why do I say that? Well, let's look on the plaintiff's side. Typically, the plaintiff's counsel will advance the costs of the claim. They view it as an investment, and they look at the claim and say, well, this claim looks like maybe we'll recover a lot of money. So it makes sense for the plaintiff's counsel to advance those costs. It's a business decision for the plaintiff's counsel. That's the way it normally works. And so the notion that, oh, there's poor people out there, they can't afford to go to arbitration. Well, that's not really the way it works. The way it works is the poor person finds a lawyer who is willing to invest the time and money to pursue the claim. That's the way it normally works, whether in arbitration or in litigation. If we get rid of the arbitration system, it's going to save the plaintiff's counsel money. So they come out ahead. Good for them. How does it benefit the defense counsel? Well, if the legislature decides to make it easier to sue healthcare providers, that's great for me. I represent a number of healthcare providers. We're going to have a lot more business. And in fact, my law partners are probably asking me, why am I here today complaining about this bill? Because it's going to give us a lot more business. But the thing is, I have lived on Guam for 40 years now, just about 40 years. In August, it'd be 40 years. And as Pramila Sullivan mentioned, after the arbitration law was enacted, we've seen a lot more options for healthcare become present here on the island. When I got here in '85, there was two big clinics, GMH, and that was pretty much it, other than a few physicians in private practice. Now we have a lot more options than we used to. But again, even though if Bill 82 is passed, I'm probably going to make a lot more money, I live here, and I don't think it's a good public policy to chase away doctors, to make it harder to practice here. We should want to encourage more physicians, specialists, et cetera, to come to Guam and practice here. But I don't think this bill is going to do that. And I think the underlying presumption behind this bill is that there is a huge amount of malpractice out there, and it needs to be addressed. And I don't think that's the case. There are, again, just from personal experience, malpractice claims are being processed. If this bill is passed, will more claims be made? I can almost guarantee it, because it will be easier. And again, defendants will make the rational decision, well, I can spend $100,000 fighting this case, or I can get rid of it for $5,000 or $10,000. But then they're going to carry that black mark the rest of their career. And so that's why I urge the committee to vote no on Bill 82. Thank you.
Thank you, Attorney Thompson. Next, we have Dr. Thorpe. You're recognized.
Excuse me. Good morning, almost good afternoon to each of you. Half a day, and Honorable Senator Madam Taitague, Chair, thank you for giving me the floor to speak, and to each of the committee members, thank you for your time today. I'm Dr. Jonathan Thorpe, Medical Director of the Guam Seventh-day Adventist Clinic, and I'm here today to voice my strongest opposition to Bill 8238. This proposed legislation, which seeks to dismantle our existing Mandatory Medical Malpractice Arbitration Act and replace it with a judiciary-focused process, presents an existential threat to our health care on our island. First, before I share about my background, I want to hearken back to the first days of medical school, when during a sacred ceremony, a white coat was placed on my shoulders, and I took the Hippocratic Oath to do no harm. As a physician, I understand the complexities of the human body and the systems we work within. My heart goes out to anyone who's experienced harm from medical treatment. Medical errors are rarely intentional, but they do occur. And the impact on patients can be devastating. And I want to just pause and acknowledge for just a second, even take a moment of silence, to recognize the immense toll that medical harm can take on our members of our community. In this highly charged environment, while accusations fly, I remind the listeners that the risk of harm weighs heavily also on the mind of practitioners. The risk of malpractice lawsuits contributes significantly to physician burnout, and we're facing a crisis of burnout across the country. Studies show rates as high as 78%. Additionally, physicians have a suicide rate more than twice that of the general population, with a significant contributing factor being the stress and emotional toil of potential litigation. I want to be clear on that. We are 2 times the national average for suicide, and the significant factor is exactly what we're talking about here today. This bill will and would exacerbate these issues and further endanger the well-being of our healthcare providers and consequently the health of our community. Before I get into some specific concerns I have about the bill, I want to share briefly about my background, and I've shared it before in this room because I think it's pertinent. And it informs my convictions on this critical matter. I grew up on a small farm in rural Western Canada, and as a son, a brother, a husband, and a father, I understand the profound impact of health on a family. My own father today is alive because of modern medicine and the Centers of Academic Excellence, surviving a rare form of stage 4 lung cancer now for a decade. Though I'm not from Guam, I identify deeply with many of the older patients I serve here, those who enjoy gardening or have small farms, those grappling with cancer and chronic disease, because I've walked that journey with my own father, a farmer and a cancer survivor. I also share the desire for medical excellence, the same wish that I've had for him over a decade. From an academic perspective, I trained at Loma Linda University and had the honor of completing residency and chief resident year in internal medicine at Johns Hopkins University, a premier institution for training in internal medicine. My wife, a nurse practitioner, and I then had a desire to relocate abroad and work outside the continental United States, serving underserved populations. After serving in Nepal for 4 years, we learned of Guam's incredible healthcare needs and that it was a federally designated health professional shortage area. We chose to come here in January 2021 for the explicit purpose of serving a community with a severe underrepresentation of primary care and specialist physicians, despite job offers elsewhere where salaries were many multiples higher. We did not have to come here. We came for service. The unintended consequence of this bill, Bill 8238, will drive away talented physicians, limiting the complexity of care primary care physicians are willing to provide. I don't intend to fearmonger by saying this. I'm speaking the honest truth, and I hope you as senators hear it over and over today. I don't understand why this is not being understood. I cannot in good faith support Bill 82 for three core reasons. One is the lack of fairness. As Attorney Thompson mentioned in much more eloquent words than I can say this morning, there's some significant concerns about the fairness of this bill. It allows for all cases currently in arbitration to roll directly into the judiciary system. How is it fair for healthcare professionals tirelessly working in Guam's austere, resource-limited environment? Guam is unique. I hope you understand that from a clinician's perspective. Dr. Nguyen gave some poignant examples of the complexity of care here in Guam. And I echo and resonate and affirm the validity of what he is saying. He's not joking when you say you get vital signs on a patient and you call 911. I've done it as of this last week several times. These people are incredibly sick. Senators, you need to understand that you can't expect to morph some mainland bill or some mainland process into Guam. Guam is unique. This bill offers zero protections against frivolous claims, eliminating crucial prejudicial pre-screening safeguards found in states with mandatory arbitration, which will weed out unfounded claims. The trend will be to go directly to settlement and putting a black mark forever on my record, irrespective of whether it was a real or frivolous claim. Bill 82 essentially strips me of my jacket. Second, the bill purports greater fairness with a single judiciary judge screener, replacing our current expert panel. I find this deeply ironic. How can a judge with no medical training, as you mentioned, be expected to interpret the nuances of decades of medical training experience? Senator Parkinson, I'd again refer you back to the hearings for Bill 11236 that we heard extensively several years ago, where Chief Justice Carbolito clearly articulated that the judiciary system was not prepared, lacked funding, and internal expertise to handle such complex medical matters. Senators, would you want these magistrates performing surgery on your child or performing high-risk medications to your parent? Of course not. And Senator Parkinson, you ask, why should doctors be exempt, be in a protected class? I'm not saying we're above the law, Senator. I'm not. What I am saying is our judiciary system themselves stated that they are not prepared, as they lack the internal expertise to handle such complex medical matters. Senator, your answer to that question is with the judiciary. Please hear them. Please listen to them. Furthermore, this bill would inevitably lead to significant delays in our already overworked judiciary system. Our current Arbitration Act often resolves disputes within months. In contrast, medical malpractice litigation can drag on for years. This means patients will wait incredibly long periods for justice. Think of what Dr. Dulabon shared a few minutes ago. Years and years later, his claims were thrown out as frivolous. This is not faster justice, it is delayed justice. It will also straddle both plaintiff and defendants with untenable legal costs, where defending a claim can reach hundreds of thousands of dollars versus arbitration fees typically ranging in the thousands. And yet my good friend will win financially with this bill. Finally, consider the immense burden on physicians. Once a case is registered in court, even if it's frivolous, it is forever on my record if a settlement is made. It must be reported to every licensing board, every insurer, every institution for the rest of my life. And how can a non-medical judge make a fair judgment on such complex issues in the sickest population in the country? And I would actually just pause and say one of the sickest populations in the world, because the United States, unfortunately, is one of the sickest countries in the world, and Guam has the rates of chronic disease almost 2 times that of the United States mainland. So we're looking at one of the most sickest populations in the world, and we're expecting our judges to make a fair and unbiased, non-partial assessment. That's a very difficult position to put our judges into. This proposed solution is completely unfair. Second key point, community harm. As an internal medicine physician, I care for the oldest and sickest patients here in Guam. We face a huge lack of specialties, forcing generalists like myself to take on a subspecialty care because patients have no other options. The dictum, first do no harm, also means doing my best to help the patient in front of me, because a disease left untreated is harmful to the patient. This bill creates a new and highly litigious environment, and contrary to what Senator Parkinson says, it will not harm healthcare providers. I'm sorry, it's baseless in that claim. Pro-litigious lawyers will scrutinize every note, seeking off-island subspecialist expert witnesses who've never practiced in Guam to question our care, even when we are the only available option. My colleagues and I will be forced to look at every patient and decide, risk our livelihood or deny care, forcing patients to fundraise to travel off-island. Number 3, talent exodus. Finally, let's address the critical issue of talent. You've heard repeatedly about the anticipated exodus or the prevention of physicians and surgeons coming to Guam. Personally, if my malpractice coverage is revoked or it's too costly to renew due to this bill, I will leave Guam. Again, I've got a father with stage 4 cancer that I'd love to go home and care for. I don't have to stay here. It's a beautiful place to raise a family. I will give you that. And it's wonderful people to work with. My hope is to stay, but I may be left with no other option to relocate where I can afford insurance and mitigate this untenable risk. Statistics from states without arbitration paint a clear picture. Higher lawsuit frequencies, significantly increased malpractice insurance premiums, sometimes 30 to 50% higher, and increased defensive medicine costs, ultimately passed on to patients or forcing physicians to relocate, as we heard earlier today, in another jurisdiction. Guam is designated by HRSA as a health professional shortage area in every specialty. Recruitment and retention are incredibly difficult. I'm almost done. I'm introducing a system that increases litigation risk will invariably exacerbate this problem, making it even harder to attract and keep the physicians and specialists our community desperately needs. I implore, 2 paragraphs left, I implore the senators to carefully consider how this bill is fair to the community you represent. It does not represent patient, it does not further patient care or make care safer. I want Guam residents to receive the same quality of care my cancer surviving father receives. The health insurers, malpractice brokers, and physicians are warning of the catastrophic increases in costs, loss of coverage, and unnecessary harm to patients, from the oldest to the youngest. Is change necessary? Yes. Is Bill 82 the answer? No. The only winner in this proposed bill is the trial lawyers. As Mr. Thompson said, I would make a lot of money if this bill passes. This should cause us pause. Many presenters have put forth actionable ideas to amend the Mandatory Medical Malpractice Arbitration Act. We need to focus on improving the existing system and empower health professional licensing boards for appropriate oversight. Senator Duenas, you mentioned a moment ago a hotel. I think we need to gather in a neutral part, whether it's underneath a coconut tree or a hotel. We need to talk. We need to talk. Let's fix the problems before they rise, and any improvement must be balanced with input from all stakeholders, ensuring a just system. Thank you so much for your time today. I again want to clearly state I ask that this bill be withdrawn or we vote no on it. Thank you.
Thank you, Dr. Thur. And at this time, I'm just going to have my colleagues ask any questions. But I do want to make for the record, Attorney Thompson, you still own a arbitration company, right?
Yes, I am a principal in Pacific Arbitration and Mediation Services.
Okay. Okay, and the next question I have is that you represent doctors, you don't represent any patients who've been claiming medical malpractice?
In the past, my former office represented claimants.
Okay.
And so I have personally brought claims under the Arbitration Act, and it wasn't that difficult to do.
So based on research, is it that patients who are claiming medical malpractice, a lot of times they can't even find attorneys because they won't take the case because of the difficulty in going through to sue any doctor or to even bring it to an arbitration case, that they find it difficult to find attorneys?
Well, Madam Chair, I don't know that I can speak on the basis of any statistics. All I really can say is based on my own personal experience. And again, my understanding is that when somebody wants to sue, let's say a doctor, they can't go to, some attorneys specialize in that type of work. And typically, the plaintiff's counsel will front the expenses, hiring the expert witness. And it just seems to me that what arbitration does is it discourages the plaintiff's counsel from taking on cases that are not really meritorious, because the plaintiff's counsel is going to have to bear the expense of arbitration. And so does the arbitration law deter claims from being made? I'm sure it does. The question, I think, is it deterring claims that should be made? And that's where I'm not sure that the arbitration law is deterring claims that should be made.
Okay, thank you, Attorney. I believe in the legislation that there is a section to weed out the frivolous lawsuits, hence, bringing these cases to the courts to determine whether to move forward on any case, whether it is frivolous or not. But I do understand the concern of the doctors, being categorized on a reprimanded through a registry, that if something like this comes about, that, well, isn't, Dr. Thor, isn't that the same case in the U.S.? Anybody who is brought in for any kind of, case against them for medical malpractice, that every jurisdiction in the U.S., and if I'm not mistaken, Canada as well. I've read the process on Canada's medical malpractice. I mean, that's just an open book there, and how medical malpractice is addressed in Canada. So, Yeah, coming to Guam would be a great place to go to avoid that. But this registry you're talking about, again, are all states that have these cases go on this registry? And you, yeah. Okay, just, yeah.
Hello?
Straight up. Okay, yeah.
I'm sorry, Chairwoman, I'm not clear on your specific question.
So the question is, in other jurisdictions, whenever there's a medical malpractice claim against a doctor, and you mentioned earlier how this, I don't have your testimony in front of me. Yeah. Please make sure, by the way, so I don't forget that you send in your testimony to us. On the
MPDB.
national database,
Yes. Yeah.
that all states are required, to, well, anytime there's a claim of medical malpractice that you mentioned, that's a national database that all states are required to notify them, and Guam does not do that.
Thank you, Senator, for clarifying your question. So I'm going to also pick up on the Canadian comment just to clarify. So first of all, about the Canadian comment, doctors in Canada don't get sued.
Okay.
In general, if I do generalize it, there is very rare cases where physicians are sued for.
Okay, but they do.
Extremely, it's very, very rare. Like I
Okay.
have hundreds, dozens and dozens of physician colleagues, and they do not worry about medical malpractice in Canada. So that's just I wanted to make clear on that point.
Okay.
And maybe I'm.
But there is a medical malpractice process that
There is,
doesn't do
but
any extreme or screening process or anything like that.
So-
it goes straight to court, correct?
Let's focus on the United States system because that's what we're dealing with here. So you asked specifically
I
about the
only brought
national.
that up because you came from Canada, that's all. So I'm sorry if you...
No problem.
But
The
anyways,
national-
to the question, because I know we're strapped and I gave you quite a bit of time to speak. So if you
Thank
could just answer the question, the
Be happy to.
database that we
Yes,
were talking about.
The National Provider Database, the MPD Bank, okay? So
Are required.
that we have to file those in Guam too. So Guam
Okay.
is not exempt from that.
Okay,
So
that
if
was
they're-
just my
and they-
question. Yeah, that's all I have. Thank you. That's just my question. I'm trying to save time for everyone so that
Sure.
everyone else has a chance to testify. So thank you. Senator Gumatauta, you're recognized.
Yeah, thank you, Madam Chair. And I just wanted to start before I was going to ask this corner, probably this on the two on the end, but when I drove up here this morning to see all of the physicians and the staff was absolutely just phenomenal. You believe and you are as passionate to the issues that face our community. And again, I just wanted to say to those, because I don't see a lot of them in here. I was a little intimidated at first. I thought I'd see a lot of people in here, but it hasn't been that way. But I know that many of them have either went back to work, but thank you again for your service. Whether it's doctors, nurses, other allied health professionals, suppliers, insurance companies, all of them, thank you for your service to all of the people of Guam. I wanted just to, if I could, because you mentioned something pretty interesting just in your testimony. And you mentioned the similar bill that was brought before this, and you mentioned about just the whole hearing, and I just wanted to kind of go back to it if I could. There was, Madam Chair, according to the committee report on, again, this similar bill in the 36th Guam legislature, the bill's primary sponsor stated at the time that claimants were required to pay filing fees of up to $10,000 or more, and then they would have to pay 3 arbitrators $2,500 each per day. Additionally, the total cost of the mandated arbitration range, and I'm sure Attorney Thompson could help us clarify, it could be anywhere from $40,000 to $60,000. The cost of the initial filing fees paid by a claimant range up to $10,000, and fees for the mandated 3-person arbitration panel are $450 per hour per arbitrator. Additionally, each party have to pay the costs of their own expert witnesses, fees, and attorney fees, a lot of stuff. But for the benefit of this panel here and members of the public who are following today's particular discussion, and I know you can't answer it because, well, they're not here, but what specific, and I mean the judiciary at Guam, what specific fees would parties in a medical malpractice case be responsible for settling under Bill 82-38 and based on the written testimony of the Chief Justice in the version previously, and then today they also offered up testimony to kind of really put a more finer point to it. I know that there's costs and fees, but could you maybe help us understand? I mean, let's start with the fees first.
Yeah, Senator Gumatato, that's a very good point, because in the past, there were a number of claims made about how expensive arbitration is. And I will say that in the past few years, plaintiffs and defendants have worked to really reduce those costs. It's true that if you submit the claim and have it administered by the AAA, the American Arbitration Association, they charge fairly large fees on top of the arbitrator's fees. However, more recently, plaintiffs and defense counsel have not been using the AAA to administer arbitration. In my 4 cases, in 3 of those, we've agreed to use a firm in Honolulu called Dispute Prevention and Resolution. They do not charge filing fees. So right off the bat, you can save a lot of money using DPR, Dispute Prevention and Resolution, out of Honolulu. And I think both sides, plaintiffs and defense, from my experience, have decided that, you know what, it makes sense to use them for a couple of reasons. One, DPR does not charge a filing fee, so you save a fair bit of money. Number 2, the panelists on DPR tend to be retired judges from Hawaii or experienced or retired or semi-retired attorneys from Hawaii. I think that's helpful because, of course, Hawaii is different than Guam, but they do have similar issues as far as being isolated from the mainland, having limited resources because they're islands rather than being part of the mainland. And so that's why I think nowadays, within the past couple of years, the parties have worked to really kind of cut the expense significantly just by using a different provider. And I do want to note, because Madam Chair asked if I was involved in Pacific Arbitration and Mediation Services. Yes, I am. We do not administer medical malpractice claims. We don't. Because right off the bat, plaintiff's counsel is going to say, oh, but your president is, you defend cases. So that's why PAMS, Pacific Arbitration, we do not handle medical malpractice claims.
All right, thank you for the gratuitous plug for the Hawaii-based group. Mitch, I'm sure that they appreciate that from you, appreciate that. I just wanted to kind of stick to this idea of, especially on the judiciary side, and I think that for the committees, for the record, I think that this is a pretty important testimony to the committee, but recognizing that aside from the lack of current rules and procedures to handle these particular type of proceedings, and I think it was mentioned previously that they also lack the budget. They lack the resources to efficiently and effectively conduct pretrial screening of malpractice claims. And I just want to go to the point that you made about the use of cameras. And in general, there's already a set of rules for certain types of camera use. We'd have to go through a whole other process. Mitch, would you agree? Just to do cameras for only this particular issue, but not just this, but other parts of this bill if it would go into law.
That's right. Now, truth be told, I have not read Chief Justice Torres' letter because I think it just came in. But my understanding was it tracked the concerns raised by Chief Justice Carbolito in response to the former Bill 112. And again, it's a little awkward for me to speak on behalf of the legislature, but the judiciary. But I imagine the concerns is that they're going to have to develop a set of procedures for this. There's going to have to develop specialized training for one or more judges that are going to be handling these cases if Bill 82 is enacted. And it's going to cost money because they're going to have, the court has a number of specialized, I think they call them courts. There's the adult drug court. There's the, they used to call it, the adult guardianship court. I'm not sure that's the correct term. Right. But they have specialized divisions within the court now, and typically they'll assign 1 or maybe 2 judges to handle these type of cases. And so these specialized division in the courses typically have their own set of rules that have been developed. And as the bill as written says, if it's adopted, every claim that's not barred by the statute of limitations can be asserted under the new law. And so potentially, all 4 of my cases that I'm defending right now, if the bill's adopted, they'll all refile in court, and then now the court's got to deal with, you know, a bunch of cases under that they don't have a process developed to handle yet.
And for a person that did not read the letter, you kind of were able, I don't know, maybe through osmosis, but you were able to figure out the argument from the judiciary. So I just wanted to say that for the record. And I do appreciate your input. I do appreciate bringing some of your insight, especially here. A lot of times I think we only think about what we've seen a lot today is a lot of white coats, but we don't get a chance to hear from our legal community. If you look at the bill itself, perhaps why it's in this committee, it has a lot to do with what's going to happen at our sister branch of the judiciary. So, Mitch, thank you, and thank you, Doc, for it was your testimony that kind of brought me. I've heard some really compelling testimony today from a lot of people, right up to you. So I felt at this point in the hearing that I would at least chime in on this particular issue relative to our judiciary. Thank you, Madam Chair, for the time.
You're very welcome, Senator Matao. Senator Parkinson?
Dr. Thorpe. Hello, Dr. Thorpe. Hi. You had mentioned that if this bill were to pass, you would leave Guam, correct?
No, I did not say that.
Oh, turn on your microphone, sir, please.
I believe it is. There
okay,
it is. Okay.
Oh, there you go. Just speak directly into it.
Thank you.
There you go.
Perfect.
Yeah.
Senator, let me clarify the exact word I said. What I said was that if the bill passes and my medical malpractice insurance is not renewed or becomes cost prohibitive, that is when I would leave.
Okay. And so where would you go that's less cost prohibitive?
I would go to the Northwest.
Where in the Northwest?
Either British Columbia or Washington State.
So either Canada or Washington State. Would you be willing to accept the rules of Canada or Washington State here on Guam?
I will abide by the rules that are set forth in law, irrespective of where I practice.
Okay, so you would be willing to accept the rules of Canada and Washington State if they were applied here?
If I had a medical license in a jurisdiction, then I am legally bound to follow and abide by those rules.
Okay, so but I'm just trying to understand, would you be willing to accept those provisions in those states? Like, do they have systems that you agree with and work?
So the difference, Senator, is, again, coming back to this whole issue of practicing in medical desert. And the issue is that the amount of support for specialty resources and referral-based networks for timely access to care is not present in Guam. So that's why I said
and so we have to take a lesser standard of accountability to recruit doctors here.
Senator, you're misrepresenting my words when you say that. I'm saying that we need to have a system that is designed to incorporate the nuances of delivering care in Guam.
So what specific nuances of this medical desert that we have here are preventing us from having the same standard of judicial consideration as every other American?
The question of how to create an appropriate environment to deliver care in responsibly and to have appropriate safeguards so that the pendulum doesn't swing too far to the left or right is a difficult one. And it's one that we have, as a medical community, have provided dozens and dozens of hours of testimony on the last bill, and we have worked with senators to bring forth legislation to improve the arbitration process, and I'd refer you back to those.
Yeah, well, this legislation is exactly word for word that same legislation that was bid here before. I changed nothing because I wanted to reintroduce the same conversation. So, Attorney Thompson, I got a question for you. Are judges qualified, intelligent enough, and judicious enough that they can rule on medical arbitration?
Well, I think I addressed that previously, but I'll reiterate. So no one is saying that judges are unqualified.
So they are qualified.
What,
is that your position, the judges are qualified?
What I said earlier was...
No, I understand, sir, but what I'm questioning is, are judges qualified?
Who is better qualified?
That's not my question. My question is, are judges qualified?
Qualified?
Yes. I'm not asking if they're better qualified. I'm just asking if they're qualified at all.
Well, under our legal system, ultimately, they can be decision makers, as Senator Parkinson, you noted earlier, in a whole range of situations.
Is that a yes, sir?
Well, yes.
So judges are qualified.
Right, but again, my point is, who's better qualified to make these determinations?
But my point is, as long as the doctors are qualified, or that the judges are qualified, what's the problem with the judges' ruling if as you say, they are qualified?
Well,
unless your position is the judges are unqualified to rule on this.
No, I think I've been pretty clear on that.
So so to be clear, the judges are qualified to rule on this.
I think what the panelists here have been trying to say is that, for example, there's reference to
Sir,
the
it's a yes or no
Indiana
question. I'm not trying to be difficult. Are the judges qualified or not?
I've answered that previously.
Is it a yes or a no? The judges are qualified or they're not? What is it, sir? I'm trying to get some clarity on your position.
I've said this several times, and I guess I'll repeat it for the third or fourth time. Yes, no one is saying the judges are not qualified.
Okay, thank you, sir. The judges are qualified. I accept your testimony. Thank you very much.
Okay, Senator Treese. Thank you, Madam Chair. I just want to note that I'm reading the court's testimony, and I don't see anything in here where they say they need additional training to become qualified to rule on these cases or even to do the pre-screening. They really are talking about the cost. They want money from the legislature in order to do this. They want, while we are paying for the judges already, they want us to pay for additional staff to help them to do this. They want time to do procedural rules. I have no problems with those things. I think those, if that's what they need, they say it's resource intensive, perhaps, that could be examined, but I don't think that they in any way are saying that they are not qualified, because ultimately, isn't it true, Mr. Thompson, in the current law, that if you're done with arbitration, the plaintiffs can still go to trial?
Yes, that's correct.
And there would be a judge making the ultimate final decision, or a jury, isn't that correct?
Most likely it'd be a jury.
A jury without any legal training or medical training, right?
That's right.
Right, so I don't know, but we're trying to put in a process, I think. Well, the bill is very clear that we are still trying to provide a pre-screening process, something to cut costs. And as you have done, the current law says that we are all going to use the American Arbitration Association, as you refer to the AAA. But you've gone outside that process. I mean, another arbitrator association, because it was less costly, right?
The current law it doesn't mandate the use of the AAA. But yes, I think that plaintiffs and defendants have agreed to utilize other providers, such as DPR, in an effort to reduce costs. Yes.
Right. So they have to do that by agreement, isn't that correct? If they are going to use another arbitrator. Otherwise, the law says you go through this arbitrator, and they're kind of subject to those costs.
Well, not necessarily, Senator Terlahi. The plaintiff picks the forum. In other words, the plaintiff can file the demand for arbitration with whichever provider it likes. So if I'm representing the plaintiff, I can file the demand for arbitration with AAA. I can file it with DPR. So really, the plaintiff kind of makes the initial choice.
Okay. And normally, well, there are ways to control the cost. That's correct. And I know that the doctors did propose that they would pay for some clients to receive arbitration funding by some fund that they would donate to. But all of those were just suggestions that they really did not implement. And that was also going to be very limited. And the bill currently outlines a process where the court, who we are already paying the judges, and you stated as well that in arbitration panels, they often use retired judges and attorneys, not medical experts, because they hire medical experts. Every side hires medical experts. No matter what process you're going to go through, you're almost always going to have to hire a medical expert to give your side of the story. From that medical expert's perspective, that's your backup. So that's where the medical expertise would come before a jury. That's how the medical expertise would come before judges. That's how medical expertise of what is right and wrong is going to come before the arbitration panel. And, you know, together with attorneys' arguments, of course, in all cases. But this is, to me, it looks like a way to, just as you can replace the AAA arbitration process to another less expensive arbitration process, this bill suggests that the cases be screened as they are in many other jurisdictions, maybe 17. They have pre-screening panels, that these be screened by someone as a judge, not a magistrate, Dr. Thorpe, but a judge in this bill. So, yeah, I just think that argument that they're not qualified to do that, I mean, I think they're going to get medical expertise if the lawyers are on their job. They're going to get the medical experts to weigh in as they would have weighed in the arbitration. And all that it does is give a very less costly way to screen those. And in the current process, I just wanted to be clear that you still have a trial. I think one of the students testified that this goes from arbitration to trial, and that's not correct. You can still go from arbitration to trial right now. This bill just says instead of a 3-panel or other type of panel arbitration where you have to pay, you can be screened here. You don't have to go off island. You can be screened here, one of the judges, who's not going to be the same judge who's going to do the case. And everything is sealed. And I wanted to ask you, Attorney Thompson, maybe you can clarify. When a complaint is filed in arbitration, and do those complaints have to be reported to the National Provider Data Bank?
Senator Terlahi, my understanding is that what triggers the reporting requirement is if there is a settlement or an adverse verdict. In other words, let's say there's a judgment that's, right, you know, that the treatment fell below the standard of care. But it's not necessarily the filing of a claim that's reportable. It's whether there's a settlement or an adverse determination.
All right. And so if there's a settlement in arbitration, is that reportable to the National Data Bank?
Well, if there's, yes, I believe any settlement has to be reported.
Okay. And if a case is sealed and it doesn't go to trial, that preliminary screening is sealed and it doesn't go to trial, there is no judgment, is that going to be reportable to the National Data Bank?
If there's a settlement, I believe it's reportable.
All right. And, okay. So you think even a sealed settlement, if they call it that, is going to be reportable?
That's my understanding, yes, Senator.
Okay. And nothing in this bill takes away from the current Board of Medical Examiners that is comprised mainly of doctors to review the actual licensing and as we do with all the other medical and other professionals, where they also have a separate board where they are also being judged. And I saw something in the media that I just wanted to address as well, where somebody said, the problem is we just need to fund the medical board and we need to give them staff so that they can do their work. But we just confirmed Dr. Berg not too long ago. He's been the chair for many, many years. And he told us on sworn testimony that he even thanked me personally for making the funds more easily accessible to the medical board. They're able to take the funds that they get from all of you and your licenses and use those to hire investigators and to clear their calendar of most of the cases. They said they've cleared their calendar of most of the cases and that they have used investigators where necessary. And if they needed more funds, it's completely within their authority to get those. And that's strictly as all of the other licensing boards are through fees. So I just wanted to put that on the record, Madam Chair, but I want to continue to listen to the rest of the testimony. Thank you.
Thank you, Senator Chalahi. Before I excuse this panel, I just wanted to ask Dr. Thorpe, because I remember going through this last time in regards to medical malpractice insurance. Some clinics are self-insured. I believe FHP is self-insured. And talking to some of the doctors from SDA 3 years ago, they had brought over their medical malpractice insurance with them to Guam. So do you have medical malpractice right now insurance?
Yes.
And does every doctor at SDA have medical malpractice insurance?
Yes.
Okay. Thank you so much. You may be excused at this time. Have a good lunch. We're stuck here, but I will stay here until I hear everybody's testimony, so no worries. Next, Jeremy's not here. We have Ninjan, Luan, not here. Okay, Melissa? Okay, Melissa, you are now recognized.
Thank you. Thank you, Madam Chair and senators who are present. You're going to hear that I have questions in my testimony, but really those questions were me trying to find answers to those that I could not find when I searched. I'm here to oppose Bill 82-38. By the way, I'm Melissa Weibel. Sorry, I forgot to introduce myself. I am a nurse. I do take care of patients, but I'm also the CEO, and I run the Guam Surgery Center, Island Cancer Center, AC Microanesthesia, and the Interventional Pain Clinic. To my knowledge, there were no conversations or roundtables that were conducted that included medical practitioners in the formulation of this bill. The bill states that the legislature, and this is in quotes, finds that the current law raises the costs of medical malpractice claims to prohibitive amounts, which prevent those who have suffered medical malpractice injuries from seeking justice and reparations. Was a study conducted to provide cost for the current system and the proposed system? Did the study include how many people are impacted? Was there any discussion on ways to reduce the cost of the current system? How many individuals have been prevented from seeking justice and reparations? These were questions I could not find answers to. This bill also states its intent was to find a fair and balanced solution for all parties involved which prioritize patients' protection. Questions again, how can a fair and balanced solution be ascertained without input from all stakeholders? Members from the court, medical providers, community members, and the legislature should have worked together to craft a bill that protects all parties. I am also a patient, not just a practitioner. I'm on both sides of that. Does arbitration need to go away, or do we need to provide funding solutions for those with legitimate claims? Guam has funding for those in need for food, shelter, power, health care. Why not for arbitration? My secondary point, it is very expensive to practice medicine on Guam. Very expensive. And all your costs are higher than they are if you were to practice stateside, including your cost to get supplies here, equipment contracts here, contracted workers here. Everything's more expensive. Guam medical malpractice insurance for the Guam Surgery Center has tripled in the last 8 years. I don't see this bill helping that to get better. I think it will get higher. And that is when we have had 0 claims. We have been in business for 24 years on the island of Guam. We've never had a claim, but yet our malpractice continues to rise, which tells me there are claims out there. They might not be in the public because they're being settled, but it's impacting my business and what my malpractice insurance costs are for sure. And I think that without arbitration or something similar to that, that's going to escalate much more quickly. And then that gets to the point of if we get to a place where we can't afford to cover our practitioners as they practice here on Guam, we would then have to shut our doors because we can't afford to not have that. So that's my testimony. I appreciate your letting us have the opportunity to speak.
You're very welcome. Thank you so much, too. Dr. Joel Joseph, you are now recognized. And just before you get started, I'm hoping to get 2 more people in before 1 o'clock, because that's when we have to shut down the streaming and then readjust. It takes about another 5 minutes, and then we'll come back on again. So please be conscious and mindful of those other 2. Thank you.
Half a day, Senators. Thank you for allowing me to...
Is your microphone turned on, Dr. Joseph?
Is my microphone on?
There it is.
Okay,
there.
sorry.
Okay,
Got to get close to it. Thank you for allowing me to speak regarding this bill. My name is Dr. Sir Joel Joseph. I'm a veterinarian. I own Wise Owl Animal Hospital. Wise Owl services up to 80% of Guam's pets. Fully staffed, we have 50+ employees. Wise Owl is the only accredited veterinary hospital on Guam. And it took us 10 years to get the American Animal Hospital Association to even consider us. Accreditation is a big deal. Accreditation is hard to achieve. I have seen many of these private practitioners get their places accredited. GMH is not accredited, and that's under your jurisdiction. You guys, the senators, are responsible for GMH. This conversation started with regard to standard of care. Everybody here is trying to get accredited. GMH can't. And yet the GMH employees have caps on all their stuff. You want to talk about a class that you're protecting, there's your class. Basically, this means that Guam's pets get higher quality care than you can as the citizens' representatives are able to offer the people of Guam. That should be an embarrassment. That veterinary medicine has a higher quality of care than human care here, especially the care that's offered by the government. This situation is on your heads as our senators. You are responsible for making sure the island citizens get quality care, and you failed. It is your failure to do your job and maintain the quality medical care that is really the issue here. Passage of this law simply shows that you are unwilling to do the hard work. You're unwilling to bring all these parties together. You're unwilling to have the answers that she just requested that couldn't find available before you even bring it to this committee, to this situation. This law just allows you to blame the physicians for your failures. If this bill passes, Wise Owl, as the only 24-hour emergency clinic, will cease emergency work, because these are the cases that are historically end up in litigation. This bill opens us up to every petty grievance, whether legitimate or not. Veterinarians get sued because somebody euthanized their pet and several months later they regret it. This is intolerable. Making it easier to sue doctors does not improve medical care. It limits it. Think about it. If this law makes a veterinarian decrease his services, imagine the curtailment that these guys will have. Excuse me. The veterinary profession is characterized by compassionate people who care for pets and livestock. We apply our training and our continuing education to the betterment of animals' lives and the people associated with them. All the veterinarians on Guam extend themselves to their limits of training and expertise. We do not have the option of flying in a specialist on or off island. We do not even have the option of flying anyone here, even under the direct supervision of a Guam licensed veterinarian, because Guam politics, which you, our senators, are in charge of, result in the application process usually taking 8 months. after which they don't want to be here and they've already found better jobs. If you are truly interested in helping Guamanians get better medical care, start in the political arena and especially in the Guam Board of Allied Health. Senators, if you do want to improve health care on Guam, do your job. Guam boards are confirmed by our senators. Guam boards are where the discussions of our standards of medical care should be. That standard of care that we all started this conversation with. Not by passing bad laws that you spin as doing no harm. So let's see what you have done in regards to the Guam Board of Allied Health. Approximately 50% of the board should be ineligible to be board members. Many of them have been there for over 20 years. This is stagnation. This is a clique of individuals supporting themselves and their personal interests at this point. Admittedly, these board members do some excellent work. They really do. But whenever you have a clique in power for that long, corruption sets in. Personal preferences set in. Personal biases set in, and personal vendettas get out of hand. I had 16 years of that, and hopefully I don't have to remind you, any of you, of that. 15 years ago, your senatorial predecessors declared openly that Guam Board of Allied Health was out of control and term limits were needed.
Excuse me, Dr. Joseph, can we stay to the merits of this bill? We're not
Yes,
talking
we are.
about the Board of
This is the
Allied
merits
Health.
of this bill.
This is a judicial system and process of medical malpractice, not the Board of Allied Health. So
No,
please, and for the sake of time, please, sir. Thank
For
you.
the sake of time, this is what the problem is. You are in charge of the boards. The boards are in charge of the medical standard of care. You never instituted term limits. You did nothing to fix the board that was responsibility. You want better health care and responsibility for the citizens of Guam in relation to health care, but you failed in yours. And I'll give you a good example of this, why you're responsible for the health care. The best example is your senatorial incompetence in regards to health care. And your continued incompetence has just been proven again. Recently, a doctor who left this island in disgrace returned to Guam after a decade's absence, roughly. Associated with this doctor's previous actions, a couple of attorney generals, the territorial veterinarians, and others associated with that doctor's actions either left island, left their jobs, or both. To say this doctor caused havoc, government expense, and embarrassment is an understatement. But what did you do as senators after this doctor returned to Guam? You confirmed her to her old position on the Board of Allied Health. Great job. Just great job. Let me be clear. This group of senators right here confirmed this doctor. Not an earlier group of senators, but those of you sitting here trying to tell us the poor quality of Guam is the physician's lot. 8 months to get a doctor here. That's impossible. The American Association of Boards, of Veterinary Boards, is a non-profit association of veterinary regulatory boards. In fact, its membership includes licensing bodies across 63 jurisdictions, including all 10 Canadian provinces, all 50 of the United States, the District of Columbia, Puerto Rico, the U.S. Virgin Islands. It does not include Guam, because the board you are in charge of to set standard of care is involved in their own self-interest to have anyone else overlook veterinarians or other of these Allied Health Board people to do the better job. You should be ashamed of yourselves. You are supposed to be vetting these people when you confirm them. You are supposed to be obeying the law. Do your job. When my patients pass away, the grief experienced by the pet owner is a deeply personal grief. And they experience the 4 stages of grief: anger, denial, blame, and acceptance. Just like when fellow human members, family members die, and the veterinarians and the veterinary staff are the punching bags when an outcome is not ideal and the patient dies. I've had one option at the arbitration board, and the guy was so crazy about it, he spent $15,000 on an expert witness. Don't tell me they can't afford this stuff. Studies have consistently pointed to a number of factors why veterinary professionals are higher at risk for suicide. We are the highest risk group of all. And I really wish you weren't rolling your eyes up in the air, Senator Chilahi. I'm sorry, not Chilahi, Taitague. I apologize. Repeated client aggression, lawsuits, social media, okay? These are the things that cause it. But the biggest thing that causes veterinary suicide are these frivolous lawsuits. It just takes too much out of us. The abhorrent behavior by animal owners that do not understand medicine nor know when to accept the best course does not necessarily reflect layman understanding. You said, when you were talking about having the judges overlook this in other states, you specifically pointed out that a judge in a certain one of the states had to have medical training. You asked if judges are qualified. You just said they're not qualified without having special training. Please, you said that people in that one state need to have special training in that one state. You did when you were doing your initial thing. Yes, that judge is capable of doing it. He's had training. A standard judge? Probably not. But we do give them that power. And you hightailing or curtailing that lawyer, Mitch Thompson, into are they qualified? That makes a good social media statement. It does not reflect reality. I'm really disappointed in you for trying to nail him on that one. The MMA is a law that has withstood constitutional challenges, organic challenges, and the test of time, literally over decades. The reason it has withstood the test of time is because it's a good law. Nobody says it's a perfect law, but it's a law that can be modified. It can be a law that can be amended. If you get all the groups together and you have a good study group like Senator Duenas was talking about. Think about opening the floodgates of litigation without checks and the balances that this law provides, the arbitration law. All the time we will spend in court. It's a lot of time. And there's one thing you haven't mentioned about the court system. It drags on, it drags on, and it drags on. And the cost is not just monetary. It's emotional. It destroys families. It destroys people. The arbitration system is fairly quick and over, unless you want to proceed afterwards, which you do have the opportunity to. Okay? Let's face it, though, really, doctors don't agree on anything.
Doctor, can you please wrap it up? Please, you're already over 12 minutes already.
Doctors rarely agree on anything. They can't even agree on the color of your mucous membranes. But you have gotten all these people together to stand up against you. And I will stand up against anyone who votes for this law, and we will try to primary them out of their next election. And that is a promise. And I hope to have the good backing of my human physicians. Thank you very much for your time.
Thank you so much. And like I said earlier, if we can continue to keep this with decorum and integrity, I really appreciate it moving forward, okay? I just allowed you to continue on because of the comments that you made were not bearing to this bill alone on the merits. You know, your discussion with the Board of Allied Health that's an issue that you need to address with them. Thank you. You are now recognized, Mr. Alexander. Right. Willard? Yes.
Thank you. Good afternoon now, Senators. My name is Dr. Alexander Bo Willard. Guam has been my home since 2017. I'm an emergency physician. I am the CEO of Guam Regional Medical City, and I'm also a member of the Guam Board of Medical Examiners. I care deeply about accountability when medical harm occurs, and I also care about preserving access to high-quality care on our island. I believe that Bill 8238 in the current form will take us in the wrong direction. As written, the bill would add significant costs to our healthcare system. It shifts more cases into the courtroom, a process that's slower, more expensive, and ultimately less effective in delivering compensation to patients. Courtroom litigation also raises the cost of malpractice insurance considerably. In fact, just the introduction of the prior version of this bill caused our only insurance carrier on island for GRMC to raise our premiums by hundreds of thousands of dollars. And they made it clear that they were very likely to exit the Guam market completely if that bill had passed. Bill 38, being a similar, raises some of the same concerns and risks. That's not a reflection of the quality of care at GRMC or on Guam. It's a function of our small market size. One large payout here can destabilize the entire insurance system. Hospitals, especially ones that handle high-risk care like cardiac, neuro, cancer, trauma, and stroke, exactly the things that we are trying to expand access to and develop the quality of accessible to our community at GRMC, they simply cannot operate without insurance coverage. If the bill passes, we risk making insurance unavailable or unaffordable, and this would in turn make it harder to recruit and retain the very physicians we need most, as you've heard from other panelists today. That means fewer specialists, longer wait times, and reduced access to care for patients. Supporters of the bill argue that this is about justice, and I agree, just as I think most of the people that you've heard from here today, they also agree that accountability matters. But if the current arbitration system isn't serving families well enough, let's improve it, not eliminate it. We already have a public fund, as I understand, that can help pay for arbitration. If that's not enough, let's build on it. But let's not create a more expensive system that delivers slower outcomes and reduces the funds that actually go to the patients and families. Finally, I know there is a concern about whether the Guam Board of Medical Examiners may be doing enough to protect the public. As a board member, I take that concern very seriously. I believe we can and must do better. I see this as a call to action, and I believe my fellow board members do as well. We can create a system that promotes justice and also protects access. Bill 8238, unfortunately, does not do that. I respectfully urge you to oppose it, and I welcome the opportunity to work together toward a better solution for Guam. Thank you for your time and your service to our island.
Thank you so much. Just for your information, there is no public fund available, as you mentioned in your testimony. It's not there. I just have a real quick question for you. What makes you think that there will be more cases going to the judicial, more medical malpractice claims going to be made if this bill is passed? Why would you say that?
Yeah, I think there's a couple of reasons. I mean, I think it expands access to the courts, basically.
I'm sorry, it expands access to the courts from the victims?
Right, so it's basically expanding access to the court system as opposed to arbitration. So I think that that's really the way, as I understand it, it's designed.
Have you read the bill, sir?
Sorry?
Have you read the bill?
Yes.
Okay, so you know that there's a pre-screening process first.
Right.
Right? And then from after that, then it can go to the courts,
right.
Correct? Okay, so again, the question is, what makes you think that this is going to be more, the more medical malpractice suits moving forward, if there is a screening process ahead?
Well, I think
of the court system.
Yeah, I think indirectly it encourages filing of suits that go through the court system, even despite the pre-training system, the pre-screening process.
But the pre-screening process is to, eliminate any frivolous lawsuits, correct? That was the intention of the pre-screening.
Yeah, that's the intention.
Right, to weed out the frivolous lawsuits before it goes to the judicial side.
Right, but I don't think that discourages the use of the court systems. I think it encourages it.
So if it makes it easier for a victim to be able to sue, or even go through a process, would you consider pre-screening as a part of an arbitration?
I think pre-screening can be helpful, but I think, my opinion, and I think it's something that you see in other jurisdictions in the U.S., I think alternative dispute resolution outside of courts tends to serve everybody better. So I think that's really I don't think that's the emphasis of the current bill, and I think that's really probably something that would suit us better.
Okay. Yeah, I thought so. I think we make it clear. I've got 5 minutes. If the okay, no questions on this side. Senator Gumatato, please. We've got about like 3 minutes before they.
Okay, I'll try to make it as quick as I possibly can. This is again, thank you for all of you in this panel for being with us. And I know this is a question that's going to go over 3 minutes, Madam Chair, but I'm glad that Dr. Wheelard's here with us today. And I'm just going to stick to my notes because it was reported through, we were talking about this committee report earlier when we were talking with the attorneys, or from the folks from in the corner here in the last panel, that there was an average of 7 cases annually involving medical malpractice in Guam, and you probably have seen them in your time. This goes back to the 36th Guam legislature. At the time, Attorney Robert Keogh, who was also invited to be here today, he informed the committee then that for his office, they had 23 medical practice claims. And I just wanted to know, maybe from your experience, do we even know if the figures today, or can you help us because you're on the board, what's the most updated amount of cases, I would say, and if that's even possible to answer in 3 minutes, and do we know any of the outcomes from this previous time, I guess, since you've been part of the board?
I might need some clarification. I'm not sure I'm following.
So those 23 malpractice claims back in, this is the 36th Guam legislature. There was 5 arbitrations. There was 5 were drawn by the client, 7 private claims that were settled with no arbitration, 4 Gov Guam claims, and 2 federal tort claims. There were a total of 23 total malpractice cases that were brought before. I guess it sounds like this was brought forward here in Guam.
Okay.
I apologize for interrupting. Yes, I apologize for interrupting. It'll give you enough time as we configure the tape right now to answer that question, but we are going to have to take a 4 minute break just so that we can reconfigure the tape for recording purposes. Okay. So in the meantime, you can figure out what the question was or find your answer. Okay. So just please give us 4 minutes. Thank you. We're in a short recess.